committee will come to order without objection. The chair is authorized to declare recess of the committee at any time. The hearing is entitled Examining the SEC's Agenda Operations and FY26 Budget Proposal, 2016 Budget Proposal. I now recognize myself for 3 minutes for an opening statement. This morning, we welcome Securities and Exchange Commission Chair Mary Jo White back to the committee. This committee is indeed committed to conducting vigorous oversight to make certain that the SEC is accountable in fulfilling its three-part mission of protecting investors, maintaining fair, orderly, and efficient markets, and promoting capital formation. By holding today's hearing, we hope to better understand the progress the Commission is making in its priorities for the remainder of the year. Now, I have no doubt the hearing will serve as déjà vu all over again for members who argue that the SEC has inadequate resources with which to carry on its mission. However, the facts are that the SEC's budget has grown tremendously over the years. In fact, the SEC's current budget of $1.5 billion represents an increase of almost 35% since the passage of the Dodd-Frank Act not yet 5 years ago. And in fact, over a 20-year period since 1995, the SEC's budget has increased nearly 400%, and that is 3 times greater than our national defense budget has grown at a time when we have to fight the international war on terror. This growth in the SEC's budget considerably outstrips most other government agencies over the similar time period. Now, furthermore, as I look to the monitors to my left and my right, which shows the rapidly rising and unsustainable red ink of our national debt, a debt that threatens to bankrupt our nation, I am reminded that the hard-working Texans of the 5th District of Texas that I represent, they have not had the privilege of seeing their family budgets increase fourfold, and they're the ones who ultimately will have to pay for this unsustainable debt, which again underscores that in Washington it is not always how much money you spend that counts, it's how you spend the money, and that leads to the SEC's priorities and agenda for 2015. The Bipartisan Jobs Act should be a priority, but regrettably, it does not appear the SEC treats it as such. At a time when the American people continue to struggle with the slowest, weakest recovery of the post-war era, the SEC's neglect of this makes no sense. Even President Obama, with whom I rarely agree, has called the Jobs Act, quote, a big deal and a, quote, potential game changer that will help smaller companies take, quote, a major step towards expanding and hiring more workers. Surely we want companies on Main Street to hire more workers, so if the SEC will not finish the work on the Jobs Act, it is incumbent that Congress do it for them. Likewise, the SEC's delay in completing its Dodd-Frank mandates, particularly in the derivatives area, has caused unnecessary uncertainty and allowed the CFTC to dictate outcomes that I believe most members of Congress did not attend. So as we discuss the SEC's budget request today, our goal, as always, is accountability. It is this committee's duty to ensure SEC resources are used wisely and efficiently and for the benefit of the American people. I now yield 2 minutes to the ranking member of our Capital Markets Subcommittee, the gentlelady from New York, Ms. Maloney.
Thank you. The United States has by far the largest and deepest capital markets in the world. We also rely much more heavily on the capital markets as opposed to loans through commercial banks than any other developed country in the world. This makes the SEC, which is our primary capital markets regulator, one of the most important regulators in the world. Because of the breadth of activities that it regulates, the SEC must constantly evolve and adapt its regulations in order to respond to new innovations and trends in the markets. Sometimes this means modernizing a regulatory regime to take account of these new risks in the market. This is precisely what the SEC is doing in two of the most important areas of the markets: asset management and equity market structure. Both of these areas have undergone significant change in recent years, and the SEC, under Chair White's leadership, has initiated ambitious efforts to update the regulations governing asset managers and equity markets. It is worth noting that both of these regulatory initiatives reflect a greater focus by the Commission on the issues of systemic risk, which is an important and welcomed development. I look forward to hearing an update on these important initiatives, as well as a potential timeline for moving these initiatives forward. Thank you. My time has expired.
Chair now recognizes the gentleman from New Jersey, Mr. Garrett, Chairman of our Capital Markets Subcommittee.
Thank you, Mr. Chairman. So the SEC is responsible for regulating the equity and fixed income markets, which we all know are vital for economic growth and the well-being of millions of hardworking Americans who invest every single day in order to buy a home, pay for their kids' education, fund a retirement. So I was encouraged, Madam Chair, when I read a statement you made earlier this year that you said, quote, "Even though you are a political appointee as Chair of the SEC, politics really doesn't come with you." And I was hopeful under your direction the Commission would finally be able to agree on a regulatory agenda that first and foremost advances only the agency's statutory mission. Unfortunately, as you know, some assert that the SEC is becoming a little more political and distracted from its core mission. For example, by my count, during the first 2 years as Chair, the Commission has already had 10 partisan 3-2 votes on major agency rulemakings. And according to a March 17th press report, quote, "Recent objections by Republican commissioners to certain SEC enforcement actions are highlighting the increasing partisan divide when it comes to policing bad actors in the financial markets." So over the last 2 years, you have what some would call prioritized thousands of hours and millions of dollars completing some special interest rules like the CEO pay ratio and the conflicts mineral disclosure rules. And the SEC also recently issued a rule proposed not called for in the Jobs Act that has and will continue to incentivize Reg D. These rules are fundamentally at odds with and distract the SEC from fulfilling its statutory mission. To see this, one must look no further than the SEC's lack of meaningful progress on some critical activities, such as reforming the structure of U.S. fixed income markets, finalizing the remaining provisions of the Jobs Act, conducting a comprehensive review to improve U.S. equity markets, and eliminating duplicative, outdated, or unnecessary disclosure requirements, particularly for these public companies. As your colleagues, Commissioner Dan Gallagher said, you are what you prioritize, so it's time for the SEC to prioritize its statutory mission over the pet projects of some special interest groups and the political staff at the White House. With that, I yield back.
Chair now recognizes the ranking member for 3 minutes.
Thank you, Mr. Chairman, and welcome, Chair White. Chair White, the SEC has a lot on its plate as it works to protect America's investors, young and old. That is why my Democratic colleagues and I support full funding for the Commission. Chair White, I'm pleased that you support a harmonized fiduciary duty rule that will protect America's investors and retirees. But the devil is in the details, and we must take care not to weaken existing protections in pursuit of a uniform standard. I would also emphasize that while SEC and the Department of Labor coordination is important, it is critical to recognize that the two agencies have different jurisdictions and mandates. I share your view that policing a fiduciary rule is vital. However, I support the approach endorsed by the former Republican chairman and Democrats of this committee, industry associations, and advocates to simply pay for more SEC examiners with a modest fee on advisors. Turning to another retail investor concern, tomorrow the SEC will vote on a rule allowing our small businesses to raise funds in a streamlined offering known as Reg A+. I'd like to reiterate that when Congress passed this provision, We rejected the preemption of state regulators because they have vital expertise in policing these smaller issuances. Finally, as you and I have discussed, I'm concerned with the SEC's seemingly reflective process of granting waivers of bad actor disqualifications. Currently, every publicly available waiver application has been granted, with large financial firms receiving the vast majority. This morning, I released a draft of my legislation to address this problem by requiring the SEC to implement a more rigorous and more public process for granting waivers. The Bad Actors Disqualification Act would no longer allow the SEC to consider waivers at the staff level, would provide the public a notice and comment period, and require SEC to keep complete public records. Already, labor, consumer, and financial reform groups have expressed their support for the measure. So, Chair White, I look forward to working with you on additional steps that the SEC can take to best deter bad actors in the marketplace. And I thank you for the conversations we've already began. I look forward to working with you. I yield back the balance of my time.
The gentlelady yields back. Today we welcome the testimony of the Honorable Mary Jo White. Chair White has previously testified before our committee, though thus I believe she needs no further introduction. Without objection, Chair White, your written statement will be made a part of the record, and you are now recognized to give an oral presentation of your testimony. Welcome.
Thank you. Chairman Hensarling, Ranking Member Waters, and members of the committee, again, thank you for inviting me to testify about the recent activities and ongoing initiatives of the SEC and our fiscal year 2016 budget request. As you know, and as the Chairman said in his opening remarks, the agency's mission is critical to investors, our markets, and companies seeking to raise capital to support our economy. We take our extensive responsibilities very seriously at the SEC. The U.S. securities markets are high speed and constantly evolving, and the industries within our jurisdiction are not static. From fiscal year 2001 to the start of this fiscal year, assets under management of SEC-registered advisors increased approximately 254%, from $17.5 trillion to approximately $62 trillion. Assets under management of mutual funds grew by 143% to $15.6 trillion, and trading volume in the equity markets more than doubled to over $67 trillion, and the products traded have become more sophisticated and complex. During this time, the SEC's responsibilities have also dramatically increased, with new or expanded jurisdiction over securities-based swaps, private fund advisors, credit rating agencies, municipal advisors, as well as others. Since I testified before this committee last, the SEC has accomplished a great deal. Informed by rigorous economic analysis, we have made substantial progress in implementing a number of very significant rules, many mandated by the Dodd-Frank or Jobs Act. These are detailed in my written testimony and include fundamental reforms of money market funds, securitizations, credit rating agencies, derivatives, and the integrity and resiliency of our equity markets. At my direction, the staff is also engaged in a number of very significant ongoing policy initiatives, including a broad equity market structure review focused on high-frequency trading and fairness, market transparency, trading venue regulation, mitigating broker conflicts, and critical market infrastructure, improvements to the market structure for trading fixed income securities, comprehensive measures for enhancing the asset management industry's risk monitoring and regulatory safeguards, and improvements to public company disclosures. We have continued to aggressively and fairly enforce the securities laws, requiring admissions in appropriate cases, filing 755 enforcement actions, and obtaining orders for more than $4.16 billion in disgorgement and penalties in fiscal 2014. We've made enhancements to make our examination program more efficient and effective, including adding industry experts, augmenting our data analytics capacities, and strengthening training programs. The agency's emphasis on technology is also continuing to pay dividends across the agency, improving efficiencies while allowing us to cover more regulatory ground. The SEC's fiscal year 2016 budget request seeks to address our current needs and the challenges we face by providing core resources. The SEC's funding mechanism is deficit neutral, fully offset by matching collections of nominal securities transaction fees, and will not impact the funding available to other agencies. As I believe we have demonstrated, we respect congressional oversight of the agency and its budget and our responsibility to be good stewards of the funds we are appropriated. Specifically, this budget would permit us to further address the pressing need for additional examination coverage of registered investment advisors and investment companies to better protect investors and our securities markets. It would allow us to continue to increase our focus on robust economic risk analysis to support rulemaking and oversight, and further bolster our core enforcement functions to better detect, investigate, and prosecute wrongdoing. It would also permit us to continue our efforts to leverage technology to improve agency programs and reduce filer burden and enhance the security of the agency's information technology. Last year was a year of important accomplishments for the SEC, but more remains to be done. Completing our congressional mandates promptly and well remains an important priority. We are continuing all of our work with intensity. Ultimately, our objective is to implement and enforce rules that create a strong and effective regulatory framework that protects investors and our markets and stand the test of time in rapidly changing financial markets. This committee's support of the agency is very much appreciated. It allows us to build upon the significant progress we have achieved, which I am firmly committed to advancing and expanding. Thank you very much. I'd be happy to take your questions.
Thank you, Chair White. The Chair now yields himself 5 minutes for questioning. Chair White, in your individual capacity, you're a member of FSOC, and then the SEC is a member of the G20's FSB, correct?
That's correct.
I think it was approximately 18 months ago, give or take, that the FSB declared that any financial intermediary not regulated as a bank is, quote, is part of the, quote, shadow banking system and must be regulated with bank-like prudential regulations. So your agency is the primary regulator of many of these entities, including asset managers, investment funds, broker-dealers. Do you believe that the legislative framework is inadequate for the SEC to comprehensively and competently regulate these entities that the FSB apparently believes needs bank-like prudential regulation?
Well, speaking for me and the SEC, I don't think that our regulatory framework is deficient. Clearly, if we saw a gap in what we needed to do and needed legislation to do it, we would be saying that.
Chair White, does that mean that when the FSB made this pronouncement, did the SEC object?
Again, if I'm thinking of the report in question correctly, what the process is within the SEC. The SEC has been a member of the FSB since 2009. The staff is on various steering committees, working groups, and to the extent that the subject matter pertains to things related to securities, let us say a report on asset managers or whatever it may be.
But this does relate to the securities market, so at some point, didn't the SEC either have to consent or object?
What I need to confirm by getting back to you is the precise report. What we do at the SEC with the FSB reports, to the final reports, to the extent that they relate to anything to do with securities. Or
if you could get back to this committee, I'd like to know.
The commission is asked to object or not. That's correct.
Has the SEC conducted any type of analysis on the impact of bank-like prudential regulation on our capital markets?
In connection with some of our rulemakings, some of our work that our economists do, there's some analysis of that. I mean, clearly we also, through the staff, and as you know, I am...
Briefly, what is your takeaway from that analysis?
Well, I mean, I think there's several, takeaways. I mean, I think it's obviously the setup with FSOC is you can designate a non-bank as systemically significant so that it's subjected to prudential regulation. As part of that process, our staff does provide assistance through the committees of FSOC, but there are a lot of different analyses that are out there.
We move on to the Volcker Rule. In January of last year, your Division of Investment Management released guidance that said, quote, primary dealer inventories of corporate bonds appear to be at an all-time low relative to market size. Late last year, the Wall Street Journal reported, quote, the bond market plumbing is clogged. Investment banks have pulled back from market making due to regulation. February of this year, Bloomberg reported, quote, bond traders are vanishing. They go on to say, quote, new regulations since the financial crisis, including the Volcker Rule in the U.S., Basel III in Europe, appear to be the causes. And last week, the Wall Street Journal reported that the Bank for International Settlements warned that the bond market is becoming increasingly fragmented and fragile. Trading inventories of corporate bonds and other less liquid assets have fallen. This is partly a reaction to regulation. Do you agree that the Volcker Rule is a contributing factor, yes or no? And then I'll give you a moment to provide context.
That can't be answered at this stage.
Well, this has been around for a while. At what stage might it be answered, and what do you say to the weight of evidence that was just presented?
Well, I think there's no question that there are concerns about the liquidity in the fixed income markets. No question about that. No question about there being concerns on behalf of regulators, including the SEC, of whatever may be causing that, and then what to do if, in fact, there's an impact, for example, if interest rates rise. As you know, Chairman Henseling, we do participate with the Fed, the OCC, FDIC in providing reports to your committee.
You agree the phenomena is taking place, but as of today, you have not found a culprit. Is that a correct assessment? Is that a fair assessment of your view? I
think what we have not identified is the phenomena differs in different stratas of the fixed income markets, and I think there's no cause that can be pointed to at this point.
My time has expired, but Chair White, I would certainly encourage you, as I know you have, to speak to the market participants because an incredible number cite the Volcker Rule in Basel III as the root cause here, and I hope at some point you and other members of FSOC will conduct an analysis to see what systemic risk could be posed by this incredible diminution of liquidity in our bond markets. Chair now recognizes the ranking member.
Chairman, if I may just say, one of the things we do at the SEC, our staff in particularly investment management, but also in trading and markets, we certainly are talking all the time to market participants. I just wanted to add that.
Chair now recognizes the ranking member.
Thank you very much, Mr. Chairman. I want to talk about investment advisor exams. As you are likely aware, I've long been concerned that the SEC is able to only examine investment advisors on average once every 10 years. Last Congress, a bipartisan group of members, including former Chairman Backus, sponsored legislation to authorize the SEC to impose a user fee on investment advisors to increase the frequency of examinations. You and your predecessor both supported this approach, as well as SEC's Investor Advisor Committee, SEC's Investor Advocate, and the state securities regulators, as well as the industry itself, through the Investment Advisor Association. Nevertheless, our committee did not even consider this issue in a hearing. In your testimony, you note that you are considering the use of third-party exams as a means of supplementing SEC examinations. When the committee last considered the use of third-party exams, such as through FINRA, the Boston Consulting Group concluded that the cost would be twice as expensive as imposing a user fee. Do you think the third-party exams will be more expensive than if the SEC were to impose a fee?
It's hard to judge that on sort of this side of doing it if we do proceed in that direction. I certainly, share, and I've testified about it many times, the concern that I have about the gap in our examination coverage because of the lack of resources. That's been the situation at the SEC for a number of years, I mean, tens of years. And I think certainly the method of whether it's a user fee bill or some other method that would get us the funding to be able to close that gap, which I think is important to close. We're smarter about our use of resources. We've reallocated some. This past year we had, I think, a 20% increase in the number of investment advisor exams that we did, but still we have the 10% coverage and 30% assets under management coverage. And so as the head of the agency, I look at what I think we need to be doing for investors and to fulfill our duties at the SEC, and then look again, as the Commission has in the past, in 2003, again in 2009, at the possibility of third-party exams to complement our OC examiners. It's not an optimal place to go, but I think we really do need to complement our ability to cover those investment advisors. Very important to particularly retail investors, but really the entire marketplace. It's lots of issues with respect to figuring that out. Who should do it? What's the expertise? What are the criteria? What are the costs? Does it apply to all investment advisors on what subjects? But I do think the time is now to act.
How would the SEC mitigate conflicts of interest that may arise from such third-party exams?
Clearly, one of the issues that has to be addressed and resolved optimally. You have that issue that is very present in any schema like that, and so you have to apply criteria as well as disclosure requirements.
How much would it cost the SEC to oversee and examine these third-party entities?
Again, that can't be judged in a vacuum, but it is certainly something that our economists will be studying.
So would you repeat one more time what percentage of the industry you're able to oversee, and how many years on average is it that you can actually do these examinations?
Well, it's a 10% coverage rate per year.
Only 10%?
10%, and that's 30% of the assets under management. We obviously try to select where we go smartly, and we do, and we've gotten a lot better at that. But and we, as I say, this past year we actually had a 20% uptick in the number of exams that we did, but it's still a 10% coverage, 30% assets under management coverage.
What is the danger that we are causing our constituents and investors with such little oversight and examination?
Well, I think you can't, as an enforcement compliance person most of my career, I think you can't overstate the importance of what we call boots on the ground. If you're not present in a space, anything can be occurring in that space. We do, by the way, supplement what we do with boots on the ground by a lot more data analysis, what are called desk reviews of information that we receive. That's good, but it's not a substitute.
Thank you. Recently, the SEC's approach to waivers from automatic disqualifications triggered by enforcement actions has drawn some criticism, especially in cases involving the largest financial institutions where waivers have been granted by SEC, mostly staff, we believe, on a seemingly reflective basis. According to one study of well-known seasoned issuer and regulations A&D waivers between July 2003 and December 2014, large financial firms received 82% of waivers, the vast majority. And as you know, today I released a draft bill that would address this problem by requiring the SEC to implement a more rigorous and more public process for granting waivers. In your opinion, what additional steps could the SEC take to engage the public in the Department of Labor, as the Department of Labor has done, in its waiver process by seeking notice and comment on waiver applications and providing the opportunity for a public hearing?
Let me just say, I think my bottom line is, and I actually talked about this at some length about 10 days ago, outside the context of a specific case, just to try to bring more transparency and clarity to what I think really is a very robust process. And and in terms of the Commission or the staff, some of the types of disqualifications and waiver decisions are made directly by the Commission. Some have been delegated by the Commission to the staff to make, but always subject to the Commission, one Commissioner even, calling them up for Commission consideration. It's an issue we're across the Commission quite focused on. So I think it is a robust process. We continue to examine it. We continue to also. Okay. I'll have to finish my answer, I guess, at a QFR. I do look forward, Ranking Member, to a further conversation on this with you, as I indicated last week when we spoke on the phone.
The time of the gentlelady has expired. The Chair now recognizes the gentleman from New Jersey, Mr. Garrett, Chairman of the Capital Markets Subcommittee.
So again, thanks, Mr. Chair. And Chair White, going to run through several questions, if you can, in 5 minutes. I'm going to start where the Chairman left off, or started with his questions on the FSB. I'm still trying to grasp how that all actually works in reality. First of all, do you actually personally attend those FSB meetings? Or do you send somebody else?
I attend the steering committee meetings. I think I've attended every one since I've been chairman. The steering committee of the FSB is the kind of the highest level of the.
You attend all those? Okay.
I attend all of those, and the staff, by and large, attends what's called the plenary. They're on various standing committees and work streams. The staff covers those in close contact with me as well as the other commissioners.
Yeah. And if the FSB comes up with something that you fundamentally disagree with that's bad for our markets or the country in general, do you feel free to push back on that?
Yes, I do feel free to push back.
And and if they come up with a position that is, I'll use the word antithetical, not good, for U.S., is that binding on you as far as your decision on FSOC? And has there ever been a case where but then has there ever been a case where they made a decision you felt that way that you pushed back? Have you pushed back at all? There's 3 questions, I guess.
Well, I'm not a quiet person, so I certainly have spoken up on various issues. But I think it's important, and this is very important to me as carrying out my responsibilities and, frankly, the agency's responsibilities at FSB. It is not binding. I mean, even a report that we won't object to have it released publicly that has various.
So you said something on that line that we never got from Secretary Lew at all. We've asked him 100 times. You said they specifically ask you whether you want to object or not. I think it was your words. So they put it to you that way?
Well, I don't know that it's explicitly put that way, but when it's a final report, it goes through the full commission for our objection or non-objection to its being published.
Right.
But what's in it, and certainly in my view, and given the nature of the FSB organization, is not binding substantively on the commission.
But he says it's a consensus-driven organization, but he can never give an example of when he's ever objected to it. Have you ever objected to the publishing or of their decisions?
The commission has, I think, raised an objection on 1 or 2 of the reports, yes.
Okay.
I think the objections were based on sort of, frankly, not enough time for the commissioners to consider the particular report rather than substance. But
now the Chair was also getting into the issue of the cumulative effect of Volcker and other rules. That was the one example where Secretary Lew actually gave us a direct answer of yes or no. He was aware that there was a problem in the corporate bond market back in October, and you were, of course. We asked him whether or not he or the FSOC has done any analysis of all the rules and their impact upon the market. And his answer, I think, was his answer was no. We could add up the cost if we wanted to. Have you ever done a cumulative study of the effect of Volcker and the other rules on the corporate bond market or in general?
Not in those terms, I think. I mean, our economists are working on various studies. Obviously, if the issue is relevant to a rulemaking we're engaged in, we're going to be, engaging in that kind of analysis.
Right. And so you're more narrow, you might say, than the entirety of FSOC as far as your view on things. So that's fair, isn't it? So would you, as a member of FSOC, encourage FSOC to be doing what we were asking them to do, a thorough analysis of the cumulative effect both of Volcker and of the regulatory impact on the market?
I mean, I think that's an important analysis to do. I mean, I know we're obviously.
But it hasn't been done, right?
I think those issues are being looked at all the time, but in the way you are articulating it, I don't think it's generated a report on that. I don't mean to be mysterious about it. I just mean there's a lot of different work streams going on.
I was sort of taken aback when he said, well, each agency is doing their own little thing, but if you guys want to do your own adding up of the numbers, we can do it. And I thought, well, gee, I thought that's what FSOC was all about, that you guys would be able to see across the entire horizon and would be requesting that. So I would encourage, well, will you request that FSOC do that?
I mean, I will certainly consider doing that, because I do think that all of those impacts ought to be being considered. I don't think it's for somebody to add them up. Yeah,
and here's a quick question, just offline, and that is, The Chair asked back in March, the middle of March, asked for follow-up of a letter back in February for release of information with regard to an investigation by members of FMOMC as far as insider trading and what have you. And we have not, I don't believe the committee has gotten any response to that letter from either March 13th or February 5th. Are you aware? I know you don't may see all the letters, but are you aware of those letters? Can we get a timely response?
I'm not aware of those letters in particular, but I will certainly give you a response, look into it and give you a response.
That would be great. Thanks a lot.
Time of the gentleman has expired. The Chair now recognizes the gentlelady from New York, Ms. Maloney, Ranking Member of the Capital Markets Subcommittee.
Thank you. Chair White, last December you gave a much publicized speech in New York where you outlined a sweeping plan to update the regulatory regime for asset managers. And at the time, you directed the staff of the SEC to come back with recommendations in 3 key areas. First, more data reporting requirements. Secondly, enhanced risk management rules. And thirdly, resolution plans for winding down asset managers. My question is, where do these initiatives stand? Has the staff come back with concrete recommendations? Have these recommendations been shared with commissioners? Exactly where does it stand?
Before I announced those initiatives, there was a great deal of discussion with my fellow commissioners and the staff about what made sense for today's markets and the risks in them. In terms of those particular initiatives, they are all very actively in process. I think the data reporting initiative is probably further along formally to some degree, but all of those are, I hope, will be acted upon in this year.
Do you have a timeline of when we might see some concrete results? Would you release the data first, and then, since that's more along, and then the others, or what's the time frame for it?
I think what you will see is, as they're ready and voted upon, they will be done in sequence of when they're ready, and I think you'll see those beginning to, come out in probably the third quarter of this year.
Okay, thank you. Following up on the asset management issue, in your December speech outlining the 3 asset management initiatives, you said, and I quote, "We must take steps to enhance asset managers' risk management programs, particularly their liquidity management." But in your written testimony today on page 12, you said that the SEC staff is considering whether enhanced risk management programs should be required, end quote, for asset managers. Does this reflect a change of view, a change of focus? Do you think it's possible that enhanced risk management programs might not be required for asset managers?
Now, I think the language does not mean that. They're really in the same place. The staff is working on such recommendations until those are actually presented and voted upon. Obviously, they're not put into, or they're not implemented at that point in time. But the wording difference does not suggest that.
So are you committed to developing enhanced standards for liquidity risk?
Yes, we do think that is a need, and that is what the staff is working on. Again, until the commission actually votes on the rules, they haven't been implemented. But again, yes, we're firmly committed. I am firmly committed to that.
And have you already started sharing this information with the
staff has briefed the commissioners on all of these initiatives. The next phases become proposals for rulemakings.
One of the main concerns of the businesses and financial institutions that I represent is cybersecurity concerns. And there have been some pretty high-profiled attacks on companies like Target and Home Depot, but there have been many quiet attacks on financial institutions. And what is the SEC's role in addressing or combating cybersecurity?
I mean, our role is and again, I think there could not be a higher priority for all of us, private sector, government sector, than to address these clearly long-term, very serious risks to our economy and really our nation. The SEC's specific responsibilities in the cyberspace relate to our registrants in terms of their own systems and what making them resilient, and then if there's an incident, reporting them. Obviously, they report them publicly if they're material. The SCI rule that we adopted in November, which is a very important rulemaking to enhance the resiliency of the systems of our critical market infrastructures, to some degree, deals with the cyber subset of that as well. We also participate, in a number of other government bodies where we all try to get together to make sure that we are coordinated. FIBIC, that the Treasury chairs, is one of those groups. We held a roundtable in March with government people, non-government people, really to bring everybody together in the same space to make sure it wasn't like you're doing this and you're doing that, and then things are falling between the cracks.
I'd like more follow-up in writing, because this is, I'd say, a concern on both the Republican and Democratic side. And lastly, what are the minimum actions that a public company should take to prevent a cyber attack?
Well, that's a big question. It depends on the company to some degree, but we've done, with respect to our registrants, one of the things we've also done is with our OC examiners, we've done a cyber risk initiative and looked at investment advisors and broker-dealers in terms of their preparedness. It varies by institution. There's certainly some common things that make sense to do. I can follow up on that as well.
Thank you very much. My time has expired.
Time of the gentlelady has expired. The chair now recognizes the gentleman from Texas, Mr. Nagelbauer, chairman of our Financial Institutions Subcommittee.
Thank you, Chairman. Chair White, in a recent March 8th Financial Times report indicates that you have about 100 SEC staffers that watch over the U.S. American equity market. But monitoring the debt market is a little bit different. We got municipal debt, $3.7 trillion market. You have 6 people overseeing that. And in corporate bonds, the size of which I think that market has grown 42% to $7.7 trillion. You have 1 employee that is devoted his time to that. But when we look at your budget and what most of your increases that you call for are for enforcement and examination, I think we're all want to make sure that you have strong, vigorous enforcement function at the SEC. But it kind of troubles me that you have so few people looking at a fairly large portion of our markets. First of all, why do you need so many more people for enforcement and for basically for some of the rules that Dodd-Frank haven't even been written yet, but yet you've allocated such a small allocation to these other markets?
So I guess several responses to that. I mean, first, I think in terms of, I think we always have to keep our enforcement function very strong. That was true before Dodd-Frank. It's true after Dodd-Frank. But I will say that one of the things that I did when I first came to the agency was sort of look at the staffing, particularly, frankly, in trading and markets, where they are shouldering very heavy rulemaking burdens, Volcker for one, Title VII derivatives for another. They oversee the markets, equity and fixed income. They're responsible for broker-dealer financial responsibility, and to really zero in on what more staffing or restructuring of the staffing makes sense to do. It's I have continuing dialogues with Steve Luparella, who is our director of trading and markets, on that. On the fixed income point per se, it isn't really organized in a way, and at least to this point, Mr. Luparella thinks it's organized as it should be in a dedicated, kind of standalone unit. But there are a number of people in trading and markets. I mean, quite a number of people that are attending to fixed income, the market, as structural issues, to the extent I've talked about some of those that we're working on to try to enhance that structure, increase the transparency, and also just the various issues that occur in those markets. Whether it's with respect to broker dealer or it's with respect to actually the trading practice rules. I could follow up on that if it would.
I mean,
sort of
I think the question is those markets have grown exponentially, but I look back, I don't see any SEC request over the years to beef up staffing in that area to keep up with fairly substantial part of the market, because the fixed income market has grown exponentially in the last few years.
I mean, there's no question about that it's grown exponentially. There's no question about its importance. I think it's also not gotten the attention over the years that the equity markets has. I think we're giving it that attention. In terms of the staffing, the the budget requests, do not come through as requests for dedicated positions because of how that's structured, as I mentioned. I can explain that in more detail as a follow-up.
Well, I also want to follow up on something that my other colleagues have mentioned also, and I think there's a growing concern about the liquidity in the fixed income market. And for example, I think some other articles have been quoted, but in today's Wall Street, it indicates that a 84% increase since June 30th means that about $640 billion, or 1 in $5 in bank security portfolios, now can't be sold because they're moving them from bonds that are for sale to bonds that are being held to maturity. And what we hear over and over again is there's beginning to be, or already is, a liquidity problem. And so then the question with, the Federal Reserve thinking about changing their interest rate policy, and as they start to increase, interest rates, the question is has anybody done an analysis of, again, pointing back, do you have even the staff to have people do an analysis of, what the consequences if we begin to have higher interest rates and a lack of liquidity in the fixed income market?
We for some time, have been talking to market participants, talking to dealers. We put out guidance, I think, last January in terms of risk management of the potential, risks that could flow, the liquidity risks that could flow from a rise in the interest rates, and so and other regulators are doing the same there. I mean, I think there was also a piece perhaps today in the Financial Times on the same subject as well. Kind of different views in the marketplace as to what's likely to happen. From our point of view as the regulators, we want to make sure everybody under our jurisdiction is acutely focused on those possibilities, at least. And we really did come out, as I say, in January, well-received guidance actually on risk management, for those particular kinds of risks. But you don't understate the issue by any means.
Time of the gentleman has expired. The Chair now recognizes the gentlelady from New York, Ms. Velasquez.
Thank you, Mr. Chairman. Chair White, it has been about a year and a half since the SEC first proposed rule for equity crowdfunding. From hearings we have conducted in the Small Business Committee, I know many firms are eager to begin using this new type of capital formation. Yet we have also heard the rules could make the process prohibitively expensive. When can we expect the final rules to be published, and how will you address the high cost for small businesses?
The crowdfunding rules, and I've spoken about them before and had hoped to complete them actually last year. They're a very high priority to complete for 2015. What we knew would be a very complex rulemaking has been even more complex to do, to both carry out the statutory requirements and to make it workable and not cost prohibitive. I actually coincidentally had a rather detailed meeting yesterday with the staff about this. It is advancing. But there are a number of issues that we're trying to solve optimally, given both the statutory requirements, the costs, and making sure this works. Clearly there's a lot of excitement in that space. So,
do you anticipate a wave of new businesses jumping into the crowdfunding market?
Hard to predict that. I mean, you certainly have the excitement and the interest out there. And we obviously have some, the Reg A plus rulemaking we mentioned before is another sort of expanded means of raising capital for smaller companies. But there's certainly a lot of excitement out there, but I think it's one that's hard to predict until it's up and running and we see how workable and how costly it may be.
Thank you. Chair White, you indicated that strengthening SEC's enforcement function will be one of your top priorities and will review policies like neither admit nor deny in settlements. Have you completed that review, and were changes made?
Yes, shortly, actually after I arrived at the Commission, and I did it in consultation with my fellow commissioners as well as the Director of Enforcement and his supervisors. I think it was in June of 2013, we instituted a new policy to require admissions in certain kinds of cases, not permit a no admit, no deny settlement in a certain swath of cases where we thought that public accountability was particularly important. We've set out some criteria for which cases that we sort of focus on for possible admissions. I think we've done approximately 20 cases in that vein. We still do the no admit, no deny for the bulk of cases, and like other civil law enforcement agencies do, and you want to be able to do that because it's efficient, you don't have litigation risk, you get money back to investors faster. But I do expect the cases where we require admissions to evolve and grow over time.
And how do you expect such changes to impact the behavior of Wall Street firms?
Well, and that's, again, one of the hardest issues to measure in law enforcement. I mean, I do think that having public accountability is an important element of deterrence, and I think that's why I made the change.
Okay. Chair White, the Volcker Rule provided the financial industry with many exemptions, including on certain collateralized loan obligations. However, some in the industry are asking for broader relief, arguing the current rule will restrict access to capital for small businesses. I just would like to hear from you, what type of business loans are packaged in CLOs?
Well, that can vary. I mean, as you know, the compliance date for those sets of issues, the Fed has postponed to give businesses a longer period of time in order to adjust to the requirements when they apply. We know there are other issues that are still out there, but that's the state of play at this point.
With the nation's largest banks holding over 95% of CLOs, is there any real risk to small business lending under this rule?
It's hard to say there's no risk. I mean, I will say this: I think the regulators are very cognizant of those issues and that possible risk.
However, we know that the largest share of small business loans are made by community banks, not the largest bank. And the data is there, the numbers are there. So that argument that it will impact small businesses, to me, doesn't hold water. Thank you.
Gentlelady yields back. The chair now recognizes the gentleman from Missouri, Mr. Luca Meyer, chairman of our Housing and Insurance Subcommittee.
Thank you, Mr. Chairman. Ms. White, thanks for being here today. I want to go down a little different road and I'll talk a little bit about your job as a voting member of FSOC. And as I chair the insurance part of our responsibilities here in this Financial Services Committee, can you give me, we've got 3 insurance companies designated as SIFIs. Can you give me the reason that you support or that you came up with or you believe that they were designated as SIFIs? What's the criteria or standards that you base that decision on?
I can, as to those that I participated in, I was actually recused from 1 or 2 of them. I think I was not recused in the MetLife matter. That, as you know, is a matter of litigation, but the FSOC put out the basis for that decision. It was made on what's called the first determination standard, which is basically material financial distress of this particular entity if it occurred, and you assume under the statute requirements, statutory requirements.
There's no list of criteria. You just look at the entity and see once through analysis whether. There
are also statutory factors that you consider. There are 10 statutory factors that actually FSOC has, by interpretive guidance, actually this was all done before I arrived as chair, but it's existent still, are in 6 categories. You look at size, interconnectedness, substitutability, leverage, liquidity. I mean, there are a number of factors that you look at before.
Chair White, you realize I've asked that question of Chair Yellen, Director Cordray, and Secretary. You're the first one that actually answered the question.
Well,
congratulations.
It's a flaw, I guess. I don't know.
I actually
but
got
I'm
an
going to
answer
keep it.
today.
I think I'll keep
Wonderful.
it a flaw, right?
But thank you for that. I guess.
But it is laid out. Seriously, it is laid out in the the public.
Nobody else would ever actually give me that as an answer. But thank you for that. I assume because it is laid out, apparently you've seen it someplace. There is a way to designate yourself. Then I take it. Is that correct?
There is a sort of yearly review, if you seek it, that could result in that.
Wow, it's amazing. 3 other ones couldn't even answer that question. Fantastic. Wow, we made some progress this morning. This is almost earth-shaking. Maybe I'll stop before I get too far ahead here. With regards to that, because of FSOC, also, they designate bank SIFIs as well. And I know that I've asked this question of some other folks as well. Do you believe that, that we need to have some regulatory relief with regards to a threshold or a set of criteria as well that's designated to allow the banks who are not systemically important to not have to fall under this overzealous regulatory regime?
There's certainly a lot of focus on that. I mean, without any question. I mean, I think that, frankly, kind of across our spaces, the impact on whether it's community banks or other small businesses.
The interesting part of this is one of the authors of the Dodd-Frank bill was sitting in front of us last summer, Mr. Frank, and indicated that this was never the intention of he or Congress to draw into their net of regulatory oversight all of the mid-sized banks, the community banks, the credit unions with regards to the SIFI situation, or insurance companies for that matter. And yet we're going down that road. I guess my question is, would you support legislation then to rein in this apparent overzealousness of the administration or anybody who is looking at this?
I mean, I really can't comment on specific legislation. I do think it presents a set of issues that's very important to consider and appropriately address. I don't mean to be hedging on that, but I can't.
Well, doggone, we were doing so well here because because not only did Mr. Frank support that position, Mr. Luce support that position, Chair Yellen support that position. So I'm sure that if you think about it just a little bit more, I'm sure Ms. White, you would support that position as well, would you not?
I don't know. I was off on the other questions, obviously. But I mean, seriously, I mean, it's clearly an important issue to address correctly. I really can't comment beyond that at this point.
Okay, very quickly. I just got a couple. I know some of the folks want to talk to you about the fiduciary rule, and it's interesting that in your statement here, you say a significant study and consideration was done of the fiduciary standard. If you did the study, can you tell us what problem you found in the study that you need to go ahead and issue a fiduciary rule?
I think the reference in the testimony to studies, I've been studying all the data that's there in the studies that have been done.
Did you find the problem?
If I have, and this, by the way, is something that I, from before I was confirmed, was very concerned about because, as I said at I think my confirmation hearing, and certainly thereafter, anytime you regulate essentially identical conduct differently, particularly in the space where retail investors may be harmed, you have to think very long and hard about that. So I've, and the SEC staff did a study with recommendations, I think in 2011.
This is a side comment. I appreciate that also because DOL is wanting to get into the space. Please don't cede your position to them. You should be the regulator of this, not them.
Well, we're separate agencies, and so I think each has to decide.
Yeah, but I think don't let them overtake or regulate in your space. That's my comment. Thank you, Mr. Chair.
Time of the gentleman has expired. The Chair now recognizes the gentleman from Texas, Mr. Green, Ranking Member of our Oversight and Investigation Subcommittee.
Thank you, Mr. Chairman. I thank the Ranking Member as well, and thank you, Madam Chair, for appearing today. I would like to visit with you very briefly about proxy access. As you know, the proxy is something that many shareholders, major shareholders, seek to have an opportunity to impact. The proxy would give shareholders an opportunity to nominate candidates. And I'm concerned and interested, if you will, in where we are with proxy access currently.
Well, as you know, there was a rulemaking overturned by the D.C. Circuit. But what wasn't overturned by the D.C. Circuit was our Rule 14a-8, which permits shareholder proposals to be at least to be sought to be put on the ballot. And this season, we've had, a great many of those. I think almost 100 actually have been submitted. So you have a lot of private ordering that's going on with respect to proxy access. There's been a fair amount of attention on it in this particular season, I think, because of a no action ruling that the staff made, and then I directed them to review the issue more broadly, and we're not actually issuing decisions on that particular exclusion in this proxy season. But there's been a lot of what I would call private ordering movement in the proxy access space, and we're very closely following that. There's not a mandatory rule, but there's a lot of private ordering going on.
Will you be moving forward to produce a rule that that will cover these issues in the near future?
I don't have any current intention to do that. As I say, there's been a lot of activity in the space that we're monitoring very carefully. Number of proposals have actually succeeded, whether by ballot or by way of negotiation with companies. So before we would make any decision, we're watching that very closely and analyzing it.
Thank you. Let's move now to your most meaningful, I suppose, responsibilities. You are, as it is often said, the cop on the beat. And currently you oversee 11,500 investment advisors, 9,000 public companies, over 800 investment company complexes managing over 10,000 mutual funds. You manage about 4,400 broker-dealers, 450 transfer agents, 18 national security exchanges, 87 alternative trading systems, 10 registered clearing agencies. A lot of responsibility. And with all of that responsibility, you do need the cooperation of Congress. And you have so much as indicated today that you appreciate the support from this committee. What is it that you would like the committee to do to further support these efforts to maintain your position as a cop on the beat that is effective?
I think, again, the issue that most concerns me is having the adequate resources to be that very strong cop on the beat. Part of being, it's not the cop on the beat, it's the compliance examiner on the beat that's also so important to keeping that bar of compliance where it should be to protect investors and the markets. I've spoken earlier in response to other questions about the need, I feel the compelling need to meet that gap in coverage at the examination level. But clearly that carries through to our enforcement function as well.
You've indicated, I believe, by way of the administration that you're in need of $222 million as an increase for FY 2015. How crucial is that $222 million?
It's critical to us. And I spent a lot of time on this for exactly where I think we need it and could use it wisely in terms of being able to hire who we need to meet our our duties. And I appreciate the support we have gotten, but it is we are in a position where we really need significant additional resources. We've tried to be very surgical about what we've asked for.
Let me thank you for your service. I know that you have a very tough job, but I do think that you're going about it in an appropriate manner. Thank you, and I yield back.
Gentleman yields back. All members are reminded that we request you silence your electronic devices, and somebody please share with Mr. Cleaver he may have a message. The Chair now recognizes the...
Thank you for exonerating me, Mr. Chairman.
The gentleman from Texas, Mr. Green, was not the offending party. The Chair now recognizes the gentleman from Michigan, Mr. Huizenga, Chairman of our Monetary and Policy Trade Subcommittee.
Thanks, Chair White, right up here in the middle. And I want to quickly hit on three things: mergers and acquisitions, conflict minerals, and pay ratio rule. I'm tempted to lead off with something else that I saw crawling across one of the cable news shows this morning about the markets being rigged, ? I think it had to do with the release of a certain book in paperback today. But we'll leave that for...
These are timed by my hearings, too.
Yes, yes. I wouldn't doubt it, actually. So quickly, mergers and acquisitions. Last Congress, I had a bill, 2274, that passed this committee and the body unanimously. 2 weeks after it passed the House, the SEC Division of Trading and Market staff issued a no-action letter addressed to 6 mergers and acquisitions lawyers dated January 31, 2014, providing M&A brokers with relief from the broker-dealer registration under the circumstances similar as to what we had described in my legislation. There was a Senate bill as well. But in effect, the SEC and my legislation had clarified some of that exemption. Unfortunately, the Senate did not take up either my bill or the Senate companion 1923, so I've reintroduced the bill as 686. So we're on the same page with that. I appreciate that. I do have a question, though. Does an SEC staff action letter giving relief from broker-dealer registration reflect the staff's judgment that covered activities do not warrant direct SEC oversight?
I'm not sure it's literally phrased that broadly, but what it certainly means
But
is,
in essence?
I would say substantially, yes.
Okay. And part of that, there was no size limit of the privately owned businesses for which the no-action relief is available, is my understanding.
I'd have to confirm that, but
It's my understanding. Would the absence of a size limitation reflect the staff's judgment that business size is not particularly of a concern to SEC?
I couldn't go that far without actually looking into it specifically, which I didn't do before I came here today, but I'm happy to get back on that.
Is a no staff or staff no action position typically reflective of the SEC's regulatory priorities and allocation of the resources and other regulated activities? So in other words, if you're saying, hey, no action letter, this is something we don't particularly want to deal with.
It can mean different things. I mean, there are no action letters that are given kind of across our spaces, so it can mean different things.
Now, does a no action letter, is it legally binding on the Commission or the Commission views? Is that how Commission views no staff?
It's not legally binding.
It's not legally binding.
No.
Hence why I believe we need to pass H.R. 686. It looks like we are on the same page. It makes sense to me that we need to fix this statutorily. So I don't know quickly if you've got anything you'd like to add on that.
No, I may supplement in getting back to you on that. But
I do intend to follow up with some written as well. And then real quickly, conflict minerals. October of 2013, you had a speech basically saying that this was not necessarily the territory that the SEC needs to be flowing into. Not that there aren't issues with that, but the SEC is not really set up to deal with these, crafting trade sanctions and articulating and enforcing human rights policies. A letter that myself, Chairman Hensarling, Chairman Garrett, and Chairman Royce sent you, you responded to very quickly. Appreciate that. But you laid out that there's been approximately 21,000 hours of staff time that has been put into this. About $2.7 million of some precious few dollars that you have in an area that you don't have an expertise in. So the D.C. Court of Appeals comes and vacates part of the rule, and for some reason the SEC has decided to appeal that. Explain that.
First, and I have to begin with, it's a congressional mandate, and my view on congressional mandates is, it's my obligation to carry them out in the most cost-effective way we can, despite the numbers that you just quoted. In terms of and it was actually a rule that was adopted before I arrived. The D.C. Court's decision came out largely validating the rule. I mean, the vast majority kind of went out of their way to say they were validating it, so we proceeded with the enforcement on that. The one issue that they did not was on the sort of the naming part of what you could conclude in terms of whether you had conflict-free minerals.
That's the shaming
It's
element.
been referred to as that, as a First Amendment issue. At the time of that ruling, there was an en banc decision, another case, totally separate, I think it was a DOJ case actually, on the same issues. And so we sought rehearing in defense of the rule. That was mandated by Congress.
Priorities as well, though, and I appreciate that. And I'll follow up on the pay ratio. I have that same concern about that shaming element may be violating the First Amendment. So thank you, Mr. Chairman.
Time of the gentleman has expired. The Chair now recognizes the gentleman from Missouri, the anxiously awaited Mr. Cleaver, ranking member of our Housing and Insurance Subcommittee.
Mr. Chairman, I apologize for Ms. Moore's phone going off.
The gentleman just earned himself an extra 15 seconds.
Thank you, Mr. Chairman. Madam Chair, thank you for being here. As you know, there is seemingly always, at least since I've been here, the bubbling up of interest in somehow reinstating the Glass-Steagall provisions. And actually, some of us at least struggled to try to get it inserted into Dodd-Frank, and unsuccessfully, I might add, in Sections 20 and 32, which deal with the consumer protection component. But the argument has continued, and I'm interested in your opinion, that some would say that the fact that we had the 2008 collapse was due in no small part to the failure to separate commercial banking from investment banking. What's your, and by the way, as you probably know, there are bills pending now. I mean, there are bills that have been introduced.
I think on that issue, that really is a legislative judgment. It really is a legislative judgment to make. I mean, clearly all the regulators since the crisis have been, very focused on reforming the existing system with the tools that we've been given to use, and I think have been used quite effectively in most cases and quite vigorously. But I think that judgment really is for the Congress.
So the SEC obviously wouldn't have a position. It's a legislative issue, as you said. But I'm wondering, does it? I'll ask another way. I think I can predict your answer. But would the SEC find it easier to do its job if we had a separation between commercial and investment banking?
It might depend on what else went with that, I suppose. I don't think I can really comment on that. I'd have to see the precise parameters of it. I mean, I think all of our jobs are difficult and challenging, but I think under any regime they are.
All right. I thank you, and I appreciate your answer. I had hoped, but didn't think I would get an answer. In October of 2013, you elaborated on your approach in the SEC in terms of the enforcement program. You stated at the time that investors do not want someone who ignores minor violations and waits for the big ones that bring media attention. And so as a result of that, you announced that the SEC would be taking a broken windows approach. I'm assuming taking that out from the book that Mayor Giuliani wrote during the 1990s. However, in securities law context, other scholars have criticized that such approach inappropriately diverts Commission resources away from major fraud and towards small-time offenses. Do you agree?
I don't agree, and I also think there's been a fair amount of misunderstanding of from that speech as to what the program is. I mean, the broken windows comments was meant to be, by analogy. I do think it's important not to neglect smaller offenses that affect our small retail investors, for example. I also think it's important, and this was really kind of the core of what I was saying, to raise the bar of compliance so that if you've got important rules out there, they're not necessarily fraudulent conduct, but they're rules meant to protect the markets and investors, and there's massive noncompliance, that you might as well not have those rules unless you enforce them. So what we've done, and it's really a very small part of our program, but to target some of those areas very efficiently, and send a very strong message that these rules are meant to be followed and they're important to follow. In my judgment, we have not diverted at all resources from the Ponzi schemes, the accounting fraud cases, which we've also emphasized. So I think it's a piece of our program.
Well, I don't think we'll have time for my other follow-up question. So thank you very much for being here. Appreciate it. I yield back, Mr. Chair.
Gentleman yields back. The Chair now recognizes the gentleman from Wisconsin, Mr. Duffy, Chairman of our Oversight and Investigation Subcommittee.
Chair White, welcome. I'm sorry. Quickly, I want to ask you about the tick size bill. You can only imagine we bring it up every time we meet. This committee passed that without objection. passed off the House floor with only 4 dissenting votes. I know you've been working on it. I wonder if you can give us an update as to where you are with regard to, are we on our way to a final rule, or what other steps may come before that?
Yes. The comment period on the tick size pilot has closed. I think sometime in February, the staff, by virtue of its delegated authority, has given the commission, and I think until May 6th, to act. I think I heard Mr. Luparella testify at a subcommittee that, I mean, that is the date. The reason, I think, for exercising that delegated authority was because we've gotten a lot of comments in that are really, we want to make sure we get this right. It's a very important undertaking, I think, for the small cap companies.
And we appreciate that. So we think a final rule on May 6th?
In terms of, that's our date to act, and I think we'll keep to that.
Okay. I would just put one last plug. I know you think you can get good data in a short period of time. I think the pilot program that you have is a year. I would just note that the pilot program that passed out of our institution was 5 years. And we want good data, but we also want good market participation. And I sent a letter to that effect, so I would just reiterate that here today.
So that's one of the significant comments that we're boring into.
Switching notes, still talking about capital formation, small businesses, venture exchanges. We've had a lot of conversations in the House. I know you have been somewhat supportive. Is there some form of a work stream on venture exchanges at the SEC? And if so, could you give me an update on that?
There is a work stream in the Trading and Markets Division, considering there's no decision made, in terms of whether there'll be rulemaking in that space, but to study whether there should be rulemaking in that space in order to obviously increase liquidity, secondary liquidity for smaller companies. We've approved venture exchanges before, so we obviously encourage those kinds of solutions and other kinds of solutions that may address those secondary liquidity issues. But there's also some legal issues with respect to some aspects of that,
right,
that the Trading and Markets Division, along with our General Counsel, ultimately will let us know whether to proceed in a particular kind of way, we may need some legislative change.
And is the SEC aggressively working through the process of thinking through a venture exchange? Or are you saying right now you want Congress to start that action? Or?
No, we're basically, very much actively in the midst of considering that and what the various issues are, what we might be able to do on our own, so to speak, with regulation, what we might need legislation for. No ultimate decision has been made, on whether to proceed.
Maybe just, quickly, I believe you're dealing with Reg A tomorrow. We have crowdfunding. We're dealing with tick size. We're discussing venture exchanges. Anything else you're doing in regard to capital formation for small businesses?
We do a lot. I mean, our disclosure effectiveness review is devoted, specifically not only to that, but to small business company disclosures, whether there should be further, scaling in that space. I reinstituted our Small Business and Emerging Companies Committee that's become quite active in the last 9 months with recommendations and advising us on various issues. We have a dedicated unit in our Corporation Finance Division that's devoted solely to the small business issues.
We had Mr. Serezny in last week in our Capital Markets Subcommittee, and we were asking him questions about the process used at the SEC, whether you're going with the administrative process or going into federal courts. He indicated there was a process that you use at the SEC, and I guess we haven't seen that. If there is a process, we would like to see it, and if there isn't one, we think that you should have a process published that everyone can see how you're making decisions as to whether you go before an ALJ or you go into federal courts.
I guess just briefly on that, I mean, obviously the decision is made in each case, but it's subject to the Commission's approval. Where a case that's authorized is filed or a settled case may be filed. I think
not to interrupt you, and I apologize,
sure,
but I mean, our concern is, I know you don't win 100% every year, but last year you won 100% of your cases, picking the forum in which you play. And it's in front of judges that, you hire and are paid through the SEC with the rules that you make. It gives us concern, number one, but number two, there should be a process that we can all look at that determines how you pick the form in which you litigate these issues. And if I could just make one last point, in regard to, we've heard a lot of complaints about the discovery. When you go through the administrative process, you don't use the federal procedure. I think it would be wonderful if you would adopt the same standards as a Federal courts in regard to discovery. With that, I yield back.
Just really briefly, and I'll get back to you on these issues. Obviously, we don't even want the appearance out there that we're being arbitrary or unfair about anything we do. I do think, and obviously these AP cases come to the Commission, that it really is a fair process. It's not identical to district court, but, for example, Brady and Jenks obligations apply in the administrative proceedings. Exculpatory evidence has to be provided. Witness statements have to be provided. You don't get that in district court, but I take your points.
There is a perception of unfairness.
Understood.
Time of the gentleman has expired. The Chair now recognizes the gentlelady from Wisconsin, Ms. Moore, Ranking Member of the Monetary Policy and Trade Subcommittee, who looks no worse for wear for being thrown under the bus by the gentleman from Missouri.
Thank you so very, very, very much, Mr. Chair. We take turns throwing each other under the bus. But Chair White, thank you so much for appearing. My first question to you is regarding any final fiduciary rule that would be promulgated. The SEC has been roundly criticized for not taking the lead on pushing this. Now that DOL has advanced its first draft, others are now telling you to stand down. I am wondering, and you have stated that Labor and SEC have quote-unquote different missions. So I was wondering if you see these different missions as being antagonistic to the goal of having a harmonized rule.
I think first it's important that we really are at the beginning of this process. This is something we've been studying a lot, looking at the studies that are there. I've reached my own personal conclusion, but the next step is for me to be discussing in detail all the aspects of my thinking with my fellow commissioners so that, what decision is made. But we're really at the beginning of that process. It's a long process. There are lots of complex issues. We are separate from the Labor Department. They have proceeded or about to have proceeded. I mean, nothing has been, with, I gather, a proposed rulemaking to OMB. They have separate jurisdiction. They have important ERISA jurisdiction over retirement accounts. And the agencies can proceed separately and will, presumably. We each have to decide what we need to do in our spaces. Doesn't mean we don't consult, and we will, to try to avoid, inconsistencies, but really separate agencies, separate jurisdictions, separate mandates.
And so separate, so I'm saying, is there going to be a rule that's sort of harmonized?
I mean, my expectation is that we'll soon see the publication of the Department of Labor's rule. It's being put out for notice and comment, and then they will presumably proceed on the basis of that. We are at the beginning of our process, so that is a separate process.
Okay, thank you for that. I would like to ask you a question about the municipal securities markets. Although the SEC's reach within the municipal market is constrained, I understand that. We've seen some renewed interest by the SEC with the MCDC enforcement program as an example. What additional steps do you think you will take to strengthen the municipal market?
As you've indicated, we are more limited in our regulatory reach there. For example, we don't have direct what I'll call disclosure jurisdiction over the municipal issuers. It's an enormously important market. It's enormously important to retail investors who are heavily invested in that marketplace. The MCDC initiative, which was a voluntary self-reporting initiative, I think was very important to that marketplace. It dealt with continuing disclosure obligations. I think it's already sent a very strong message that's raised the bar in that space. We're also looking at just the structural issues in the muni area as well, working with the MSRB, who we oversee, in terms of approving a best execution rule, for example, better disclosure on what's called riskless principal transactions. We've brought a number of enforcement actions to really hammer home the point of investor protection.
I thank you so much. And then finally, forgive me if others have asked about the 7% increase in funding relative to your FY15 budget for enforcement program. Is there any particular activity that you're going to focus on with these extra resources?
There are a number of areas, but those are really targeted to getting more market experts and litigation trial lawyers. We have more trials now. We have to be prepared to have more trials, as we now require admissions in certain cases. May or may not, lead on a permanent basis to more trials, but those are two of the areas, as well as data analytics in that space.
Okay, thank you so much. I yield back my time.
Gentlelady yields back. The chair now recognizes the gentleman from North Carolina, Mr. Pittenger.
Thank you, Mr. Chairman. Chair White, as you are aware, in July of this year, banks of all sizes, including community banks, are expected to be in compliance with the VOCA rule. My question is related to covered funds and the legacy securities. As you may be aware, members of the financial industry have put forward a limited proposal to ease the compliance burden for banks of all sizes when it comes to the ability to invest in and make markets for certain securitized products. Basically, the proposal that you should have received creates certain assumptions for legacy securitizations to determine whether they fall in or out of the covered fund definition. To me, it seems like a fairly straightforward and limited proposal in order for the industry to comply with the VOCA regulations. Are you familiar with this proposal?
I'm aware that there is one, but I would have to get back to you on specific reactions to it.
When do you think that there might be a response back to the industry that they submitted related to this VOCA compliance?
I can't really answer that, but I can supply an answer to that question as well.
Okay. Well, it does seem to me that failure to ease these compliance burdens on this threatens to harm the liquidity associated with the securities. Would you agree with that?
It certainly is a significant issue. I really can't go beyond that because it's obviously something before us.
Sure. Chair White, do you expect that the SEC will issue a final pay ratio rule in 2015?
The pay ratio rule is, as we were alluding to earlier, a congressional mandate that we expect to proceed on, I think, in 2015.
Sure. Does SEC evaluate whether a specific regulation is tailored to impose the least burden to our society? Would you agree with that, and including market participants, individuals, different sized businesses, and other entities?
We certainly are very sharply focused on that. Obviously, if we have a congressional mandate that's given to us, my responsibility, our responsibility is to carry that out, but in the most cost-effective way as we can.
Does the analysis consider the cumulative cost of regulations and evaluate whether this regulation is inconsistent with or incompatible with the duplicative of other federal agencies?
We certainly include that as part of the analysis whenever the data is available.
Do you consider the potential regulation or investor choice, market liquidity, or for small companies?
We do.
I would like to talk briefly about the SEC budget request that your agency recently submitted. The $1.7 billion for FY16. That is correct that you've testified?
Yes.
Do you know what the SEC's current budget is?
It's approximately $1.5 billion.
Yes, ma'am. How much has this increased since 2010? About 35%, is that correct?
I can't give you the precise percentage, but there have been increases.
Since 2000, what would that percentage be? Do you know?
I don't know the precise percentage. I think I said a little bit earlier, trying to match up the percentages and changing our marketplace and responsibilities.
400%, that's my understanding. The SEC also has about $75 million contained in its reserve fund. Is that correct?
Yes, and I think $52 million of it would be usable.
And another $74 million in unused funds, is that correct as well, that carry over from the prior year?
We have no-year funds at the SEC. I think we've been working on spending those balances as currently as we can, but they're part of the current budget planning, yes.
Are you aware that the observations of many that there's just been a misuse of funds in recent years and regarding office space and purchasing of computers and the like for non-existent employees?
Not precisely that, no. I'm certainly aware that there have been prior issues that have been raised in terms of leasing space, which I think have been corrected some time ago, and we're very focused on reducing our space footprint. In fact, one of our cost savings, I think, has come from our real estate initiative that we've done to really reduce that that's our space requirements even more. I think it's about a $3 million savings annually that in that one space. But there have been issues in the past that I think the agency has worked very hard on and successfully on. I'm not going to say there are no issues in any agency.
As a taxpayer, those that I represent, the gross increase in terms of the budget requirements these are large numbers, and they're a real concern in the accountability of how those dollars are spent. I yield back.
Time of the gentleman.
I take that accountability very seriously.
Time of the gentleman has expired. The chair now recognizes the gentleman from Massachusetts, Mr. Capuano.
Thank you, Mr. Chairman. Thank you, Madam Chair. Madam Chair, just a general question. If I owned a corporation, I had 100 shares of stock, and I sold them out to 100 different people, who owns the corporation?
The shareholders always own the corporation.
Shareholders own the corporation. So they own the corporation, yet I have two issues then with the SEC. If you believe that, which I'm glad you do, because I was afraid we're going to have an argument on that, could you talk to me about why then the shareholders have no right to know what the thing that they own, their money? Could you talk to me about why they don't seem to have a right to find out what the thing they own is spending their money on politically? And could you also tell me why the SEC has been, you did something good to begin with, but you got pushed back, but then nothing in 5 years on proxy access? Why 3% of the, if you own 3% of the stock and hold it for 3 years, which I think is actually a pretty high bar, you still don't have the right to even nominate somebody to the board. If you own this company, why do you not have those rights? And why does the SEC not stand with the owners?
Well, I think the SEC does stand with the owners in many, many spaces. I think we talked a little bit earlier about proxy access and where that sits after the reversal of the rulemaking. It didn't reverse
5 years ago,
but it didn't reverse the 14A8 shareholder proposal piece of that, which is being very actively and I think successfully used by shareholders. And this season is particularly active there, and I think we've been impartial but supportive there. I think we've talked before, and I about the political contributions issue. I appreciate the very strong views on that, and I think again what you've seen there is no specific disclosure requirement in that space unless in the circumstances of a particular company the matter is material. And so we've gotten a lot of letters on whether we should do a specific line item disclosure requirement on that. Very strongly held views on both sides. It's not currently, and I know that's a frustration, on our agenda. We're very focused on our congressional mandates and so the other priorities.
It's not a frustration. It makes me wonder whose side you're really on. I mean, the words are fine. I like everything you said. But the truth is, like everything else, I judge people on what they do, not on what they say. And if you say you're with the shareholders, then let the shareholders do what they do with their own stuff. I wouldn't come to your house and tell you what you should do with your money, nor should you tell me what I should do with mine. And if I own, I think, 3% in 3 years, why shouldn't I be able to nominate somebody to the board?
Well, again, there are provisions that permit that to happen.
Why doesn't the SEC stand with the shareholders then?
Well, I think again, we talked about the proxy access rule, but we also talked about the shareholder proposal avenue for presenting proxy access proposals.
I get.
I think that is.
I understand what can be done, but I would argue that the SEC, if you actually do believe that shareholders own the corporation, you should be pushing harder for the shareholders to actually act as if they own the corporation. And I understand what they can do. I understand that some people are doing it on their own. Congratulations to them. But there are others that would like to do it that can't get it done. And I would suggest that the SEC should stand with them, as opposed to stand by the sides neutrally and say the right things, but do nothing about it.
I don't have a further response to that other than, I think the shareholder proposal process is working very effectively. We're very closely monitoring that to see where it goes by way of private ordering.
But you're not willing to take an active part in it. You're just watching it.
Well,
I have a lot of professors who do that, but they're not the chair of the SEC.
Certainly our division of corporation finance is quite involved every proxy season in terms of the shareholder proposals. But just to be clear, as we are not at this we are not advancing a required disclosure rule in that space.
You see, and here's the problem. Most of my constituents, including people in the business, don't really think that the SEC has ever is certainly not now, stood with them. They think that you're captured by the people that you're supposed to regulate. And I think that these two aspects of it, simple things, I'm not trying to turn the boat upside down. I'm not trying to put an underlying shake in the American financial system. Simply trying to say that people who own something should have some say on what their thing that they own does. At least have some knowledge. And I would also suggest that if you believe that, you should be standing with the shareholders, giving them this much more confidence, not less. And my time is up, and I appreciate your answers.
Time of the gentleman has expired. The chair now recognizes the gentleman from Ohio, Mr. Stivers. He takes notice that today is the gentleman's 50th birthday. I've been informed he doesn't look a day over 55.
Thank you. Thank you, Mr. Chairman. Chair White, I'm over here. Good to have you here. Thanks for what you do. Real quickly, I want to hit proxy access and then fiduciary rule, and then if we have time, MCDC. So with regard to shareholders, do shareholders get to approve or deny every proposal that comes up in every public corporation, and do they get a chance to either vote up or down every director that comes up for a vote?
If it's on the proxy, yeah.
Yeah. Thank you. So that sounds like they're acting like owners to me. Can we quickly go through the mission of the SEC says from your website that your mission is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. Is that right?
Yes, it is.
So, and I want to talk about the fiduciary rule here for a second. So the Commission did a study in 2011, but in that Commission study on the fiduciary rule that was required under Dodd-Frank, did it look at the cost for investors, especially small retail investors?
That's certainly one aspect of what we continue to study.
Well, my understanding is it was not in the study in 2011. Am I wrong?
You may not be wrong. I can't answer
I
that
believe it
without
was
looking
not in
back.
the study, and I'd like to. I just want to put something out there for your thoughtful consideration. I just met with 3 young, fairly new employees, and they participate in their company's 401k plan, and they put just a few dollars every paycheck away. If you change the standard for people like Linda and Mark that I just talked to, what could happen is they could be priced out of the market because the fees are going to eat up all their money, and they're not going to be able to form capital in their own. And I know capital formation is about business, but people form capital too, and they need to be able to save for their retirement. If you change to a standard that eats up all their cost with fees, it's going to kill them, and it's going to kill their chance to save for retirement. And these are 20 and 30-year-old folks I was just talking to, and we were talking about other stuff, but because I was getting ready to talk to you, I asked them about that. And all of them do participate in a 401k program. And as you think through what you're going to do, I would hope you would think of folks like Linda and Mark and what your changes could mean to their ability to save for retirement. Because what happens when we make a standard that might work for big corporations and rich people, it leaves the little guy out. And that's what I want to talk about on MCDC too. So I just want you to think about that as you go through this, because that's what could really happen here. It's what we've done with Too Big to Fail. We've hurt our community banks by setting requirements for the big guys. It's what could happen in the fiduciary rule, and it's what could, I think, is happening in the MCDC. So these fines that you're getting, MCDC, I understand you wanted to understand the disclosures of your municipal underwriting folks across the country. And for the big firms, the biggest firms, the fines that are about to be announced in 3 tranches for you are going to be a rounding error. But for little guys, it can put them out of business. And what we are doing by having a big government through Dodd-Frank and other things is we're squeezing out little guys. We're squeezing out the new entrants to the market. And I just really worry about it. And I want to ask you what you've learned from the MCDC process. It's new. That maybe you could use to make sure that you don't create a system where, you have to be big to be involved in municipal securities. What have you learned to make sure that the little municipal issuers aren't going to get squeezed out and pushed out by the fines and the liability and the things they didn't know? and I'll give you a few minutes to answer that.
Yeah, I mean again, I think we saw a significant problem in that space. I do think the MCDC initiative has been, even to this point, quite successful in addressing that issue, but clear and scaled in terms of how one would, deal with any outcomes. For example, issuers not being subjected to civil penalties, and obviously size matters in that. We always have to be careful about that. On the fiduciary duty, I think it's important to act in that space, but it's really for the benefit of retail investors that if we are acting, that's who we're acting for. And at the end of the day, and I think I said this publicly, we end up basically depriving small investors of reasonably priced, reliable advice. We obviously would have failed. And so it's a complex undertaking.
It is. And the same thing with the MCDC. And I've heard from the small issuers, and I have a lot of small towns that dot my district, and they will have problems getting access to capital if you do the things like the MCDC wrong, because little towns won't be able to issue municipal bonds. I'm sorry to go over, Mr. Chairman. Thank you. I yield back.
Time of the gentleman has expired. The Chair now recognizes the gentleman from Minnesota, Mr. Ellison.
Thank you, Mr. Chairman and Ranking Member. And thank you, Chairwoman White, for being here. You've already indicated that the SEC would issue a rule on CEO pay median worker ratio in 2015. Thanks for that. I would like to simply submit this letter to the record without objection.
Without objection.
That we sent to you, and Mrs. White, you've received this letter, and it's the will of at least 58 members of this body, and perhaps even more than that. And again, I think it's relevant to a lot of people, not just the public at large, but investors. I think research shows that higher ratios correspond to more risky investments, so something that I regard as important. I appreciate your attention to it. Also, I wish you would comment on a few other matters regarding the fiduciary rule. Conflicted investment advice costs investors more than $17 billion a year. And I'm very concerned that workers are sold IRAs with high fees and hidden commissions that damage their retirement security. And I'm supportive of the Department of Labor's decision to move forward with a rulemaking to protect workers. I was wondering if you could comment on why you chose this month to announce that the SEC was going to move forward with its own fiduciary standard.
Yeah, there's no connection to, but I understand the question, to the Department of Labor's announcement. This has been something that, as I mentioned earlier, I've been very focused on since before my confirmation. I think it's an enormously important area. I think the Department of Labor is addressing a very important area. Their ERISA mandate over retirement accounts with what they're doing. We're separate agencies. The SEC has been also studying this before I arrived. Obviously, there have been studies that have been and reports that have been presented. I've spent an enormous amount of time with our staff dealing with really what are quite complex issues in order to be able to forward this. I think it's important to forward it. We're really in a sense, at the beginning of our process, but I do think we should, as a separate agency, proceed with a rulemaking.
Yeah, I noted that. I think you made your announcement at the Securities Industry and Financial Markets Association, which, as is its right, it's certainly its right to spend more than $7 million lobbying Congress, in part to kill a rule that protects hard-earned retirement savings for workers, and that's where you made the comments that you made.
Well, I mean, this is, I said what my position was when I knew what my position was. I think I had indicated at a prior conference at the end of the year, I don't know if it was there or at a different conference, that I expected to be able to at least state my own personal position, which is all that I've stated, last year. And so in that particular audience, which has, representatives of the investment advisor space as well as the broker-dealer space, both, I thought it was quite an appropriate place to, since I was ready to say what my personal position was, and people kept asking me, for several months, that it was quite appropriate to make that statement there.
Is there any coordination with the DOL rulemaking process, or are you just kind of going forward? on your own?
We've provided, and really since their initial proposal, and obviously long before I got to the SEC, I think their initial proposals in 2010, the SEC staff has provided technical assistance and expertise to the Department of Labor in terms of, how this market space works, in terms of, our registrants, what potential impacts we see on investors and the availability of investor advice if the rule changes are made. I would expect us as we go forward to continue to, consult, which I think is very important.
Do you think it makes any difference whether DOL goes first or your agency goes first?
I think we're separate agencies, and we need to proceed separately when we think the time is right and we have something we think we should be advancing.
So that'd be like a yes. You do think? I mean, I guess you're saying that you should separate.
There's no reason that there's no reason that
coordinate.
No, I'm sorry. There's no reason to coordinate. No, I'm saying we're separate agencies, and therefore I think each agency has to decide when to go forward. Clearly, you take cognizance of whatever other regulators do all the time in rulemakings if they go first. We have a similar situation with our Title VII rulemakings, where the CFTC, for the most part, has gone first, as we've heard alluded to.
I'll have to follow up in writing because I'm out of time, but thank you for your answers.
Time of the gentleman has expired. The Chair now recognizes the gentlelady from Missouri, Ms. Wagner.
Thank you, Mr. Chairman. Chair White, thank you for joining us today and talking about the SEC's agenda. You've had a very busy year so far, and I'd like to start by bringing up a few things that you've said recently on the SEC moving forward with the Uniform Fiduciary Rulemaking, my favorite topic. In a speech from February of this year, you stated that a priority for the SEC would be to determine whether to adopt a uniform fiduciary duty for broker-dealers, and my heart soared, Chair White. And just a month later, you announced that it was your own personal view that the SEC should act under Section 913 of Dodd-Frank to implement a uniform fiduciary duty, and that the SEC would, in fact, move to implement these rules. Now, this seems like a pretty quick turnaround on your part, yet in your speech you didn't mention any kind of what I would call formal analysis performed by the SEC that maybe would have prompted this kind of sudden change. Chair White, I'd like to ask what exactly did change over the course of just 1 month?
This isn't an abrupt event, but let me explain. Essentially, Dodd-Frank gives the SEC the authority to decide whether to impose a uniform fiduciary duty.
Correct.
So the decision for the Commission is whether to do that and then in what form it would take. What I have done, and as I say, I've been very focused on this issue since before my confirmation. I've worked extensively with the staff on all of the many complexities, the data that is developed to date, and reached my own personal decision that I think the SEC should proceed with a rulemaking to impose a uniform fiduciary duty. Lots of challenges to that. The next steps, and this is not a quick undertaking. The next steps are to discuss in detail all aspects of this with my fellow commissioners, while the staff is working on recommendations.
Following up with what Mr. Ellison was talking about, and this, in fact, didn't have anything to do necessarily with the Department of Labor announcement that they were moving forward on their own rulemaking in that time?
That is correct.
Has nothing to do with that.
No, and I have said long before the Labor Department announced this that I was going to soon say what my own position was. That's back last year, and I've been working very intensively on it.
And you just mentioned that it was your personal opinion. Tell me about what kind of studies, analysis, some kind of empirical basis for moving forward with the rulemaking.
Well, you have a number of studies. Some of them were actually accompanied the 2011 report that the SEC staff made that talks about one issue is, and it's just one issue, talks about investor confusion. I think there's no question that the standards under which broker-dealers and investment advisors operate under are different. One being a suitability standard, one being a uniform fiduciary duty standard, where the best interest of the client.
Has there been any formal analysis done, any economic analysis done and presented for such a rule?
There are studies on this, but part of what we will be doing with this undertaking is continuing to have our economists study all aspects of this.
And you just mentioned it. Do you believe that a rule should just demonstrate that there is actual harm to the investors rather than just confusion?
I think confusion is not a good thing in and of itself, and when one would regulate differently. I think if that was the only issue. I do think when you have two very different standards where financial professionals under the same rubric can make different decisions, one having to make the decision in the best interest of the client, irrespective of their own financial interests. The other doesn't have to do that if the investment is suitable. That's an effect.
Being cognizant of my short and limited amount of time here, I would really encourage, you said you were going to have your economists look at this, to actually dealing with the area of harm versus the standard of care as opposed to any other standard or confusion. True actual harm. Has any study conducted by the SEC taken into account the potential for increased costs? I know that Representative Stivers mentioned this. He talked about broker-dealers, about investment advisors, and more importantly, what I care mostly about, which is the retail investors, the Lindas and the Mike and the Marks that he spoke of.
No question that's part of the analysis, and it is in all of our rulemakings, but particularly acute in this one.
And just one other quick question. Many have argued that changes to disclosures as well as simplifying the kinds of titles that can be used by financial advisors could help solve some of these issues. Has the SEC considered any such alternatives instead of a brand new, overarching, new fiduciary standard?
Well, the answer is yes. I don't think they're mutually exclusive, though.
Time of the gentlelady has expired. The chair now recognizes the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman, and Madam Chair, thank you for your attendance. I really appreciate it. My favorite topic is actually market structure, and I'm happy to see that in a number of let me slide over this way so I can see you, that in your testimony you raised some concerns that I share. I recently drafted a bill called the Maker-Taker Conflict of Interest Reform Act. And this is what we're trying to do is we have a system now where exchanges are offering all kinds of incentives for order flow. They're offering co-location for a fee. They're offering special order types that will allow traders, brokers to get to the top of the queue. And now they're offering significant rebates to brokers who will steer their order flow through their exchange. And the thing I worry about is that the brokers, in some cases, not all cases, are chasing order flow and chasing those rebates instead of acting in the best interest of the investor. And I think that's very, very important for retail investors and pension funds, things like that. And so what I was trying to do is to figure out what the impact of these rebates really is. And the least intrusive way, I think, to do it is to do a pilot program to pick out 50 or so highly traded stocks and prohibit rebates to be offered on those stocks, so that we would see, obviously, if brokers are trying to chase rebates, we would see a lot of activity in the stocks that carry the rebate, and we would see far less activity in those that don't carry the rebate. I'm wondering if the SEC is considering anything like that, where we could try to realign the interest of the broker with the interest of the investor.
Very much so. I mean, the maker-taker compensation model is very much in the core of what our market structure review folks are looking at. I mean, a pilot is a possibility to be able to sort of come to grips with that issue. It's a complex issue.
Oh, yeah.
I mean, it's a very complex issue. We have our economists deeply involved in that, and they have, as in those discussions have said, there really are a number of complexities if we were to proceed with a pilot study that you need to control for. There's certain non-public information, for example, that really would need to be a part of that. Getting the right cross-section and a large enough one would be very much a part of that as well. And so our staff in Trading and Markets is actually preparing quite a detailed analysis of that in conjunction with our economists. It will undoubtedly be on an early agenda for our Market Structure Advisory Committee, which is a cross-section of experts and perspectives to give their feedback on it. But we really do think
is that the committee with the 17?
I think it's 17. I think it is 17. Okay. I think it is 17. I think the first meeting is I
would like to see some of the
May
folks
13th. Yeah.
On that committee. I would like to see some of the folks that have been quite outspoken on this. Sal Arnott, Joe Saluzzi, Chaim Bodek. Those are all real smart fellows that have been dealing with this high frequency. They probably don't want to serve on it, but I'd just like to see some people who are publicly suspect of this whole the high-frequency trader advantage.
And clearly our intent is to get that balance in those different perspectives and to the extent someone may not be on the committee that has perspectives and expertises. I mean, there are more than 17 quite expert representatives. We intend to structure those meetings with a large, I don't know if it's a round table at each meeting, but it is with additional inputs at those meetings, so that we can get broader participation from folks such as you mentioned. But it is something we're very focused on, very deeply studying. It is complex. I just and I'm happy to have the staff follow up with you.
Yeah, that would be great. I just want to say this, Madam Chair. This issue really affects the integrity of our markets. So I know it's complex. Everything's complex. Sometimes I think complexity is an advantage for some people. And I just think for the protection of our markets, we got to get a situation where a retail investor or a pension fund is not at a huge disadvantage to a high-frequency trader who has a special order type and has co-location and has the advantages of speed, and in some cases there's an information advantage that they have as well.
There are a lot of issues like that. I will say in this space you basically have the concern about the conflict of interest for the brokers as it may impact the investor, but you've also got a concern that it's yielding better prices and less costs for those retail investors.
Thank you, Madam Chair. I appreciate the indulgence of the Chair. I yield back.
Time of the gentleman has expired. The Chair now recognizes the gentleman from Florida, Mr. Ross.
Thank you, Mr. Chairman. Madam Chairwoman, thank you for being here, especially for your cooperation and your testimony today. I want to go back to what the Chairman alluded to in some of his earlier questioning, and that has to do predominantly with the imposition of prudential banking regulations on non-bank financial institutions such as asset managers and insurance companies, life insurance companies. Shouldn't the FSOC's primary focus be on making sure that these entities that may have systemic risks, that those are addressed properly rather than turning them over to the Fed to just say, here's a bank-centered prudential banking regulator, you assess it? Wouldn't it be better to put them within the regulator that they already have?
I mean, certainly one of the strong components of FSOC is to have primary regulators there in the process.
Right.
Clearly, FSOC by statute was given the power to designate non-banks that are systemically important to subject them to.
Correct. But it would be good to put them with their primary regulator for addressing their systemic risks.
Although it's not how it's structured under the statute, but I mean, one of the things that's clearly at the moment where the asset manager review is sitting is to get more information on activities.
Correct. And one thing I want to thank you for, I know that you mentioned back in December that you were going to help develop recommendations to address potential risks in the asset management industry. In fact, one of them is to improve, expand, and update the data and other information the SEC uses to draw conclusions about the risks of asset management industry and develop an appropriate regulatory response. How is that coming?
Actively and productively, proposal is being produced by the staff.
Do you feel that, or let me ask this, how if they did it all, did the asset management industry contribute to the 2007-2008 financial meltdown?
Well, I mean, I think everybody has different things that they point to, but I don't see a lot of fingers pointing to them.
Yeah, and they're really not. I mean, they manage other people's assets, and I appreciate that.
It's an agency model predominantly.
And I appreciate that. And last month, for example, FSOC came out and said we've got some transparency regulations we're going to follow, and I think that's a good step in the right direction. How would you feel about codifying those transparency requirements?
I think transparency is enormously important for FSOC. I mean, any government agency. So I also applaud the steps that have been taken, and I think additional steps could be taken as well. I think one of the I was about to say one thing that I think is smart to do is it's a relatively young organization. And you want to make it stronger as you go. You don't want to sort of freeze it in place, maybe with codifications.
And not only that, but also with the codification, you don't subject yourself to the whim of different administrations, regardless of who may be in charge. But also, when you're looking at the designation of a systemically or significantly important financial institution, you want to be concerned, I think, at the very core of how they got there, and to give them notice as to, one, that they're now being considered, and two, here is a path to get away from it. And if we were to codify some of this, I think it may give not only the entities themselves, but more comfort to the market. And so to that end, I just wanted to make you aware of a particular bipartisan bill that I've just introduced yesterday, known as the Financial Stability Oversight Council Improvement Act of 2015. It codifies the transparency. It allows for the procedures for SIFI designation of non-bank financial institutions. It allows for the primary regulator to be provided the opportunity to address the systemic risks. So I just want to make you aware of this and hope that you'll take a look at this and have an opportunity to even, quite frankly, support it if you're in such a position. Also, earlier you talked about in your opening that you look at, you provide a robust economic risk analysis when looking at the markets. Does this also include a cost-benefit analysis of the imposition of regulations?
It does for our rulemakings, yes.
And for example, with regard to asset managers, again, because I've been burying myself in this for a while, there was an American Action Forum that did a study in 2014 that said that an asset manager or mutual fund designated as a SIFI could decrease investor returns by as much as 25%. When you look at a lot of investors that are utilizing asset managers to invest in retirement funds and college education funds, it almost becomes a cost prohibition to have this designation, when in fact, according to this study, that an investor can lose as much as $100,000 over the life. So that's something I hope that you would, if you haven't already, take into consideration with regard to the imposition of these non-bank centered financial institutions.
The only thing I'd comment on is what you're looking at in that process is the systemic risk as part of that.
Correct.
As well.
Thank you. I yield back.
Time of the gentleman has expired. The Chair recognizes now the gentleman from Connecticut, Mr. Himes.
Thank you, Mr. Chairman, and thank you, Madam Chair, for being with us and for the good work that you do. I want to reserve the bulk of my time to talk a little bit about insider trading, but want to weigh in on this active debate we have on the question of a unitary fiduciary standard. I would hope that most of us would want that the nature of that fiduciary standard to prevent people from paying money for products that are sold in which the intent in selling those is more about making money than it is providing the best product. But setting aside the substance, and I understand that you're statutorily constrained by a system that was set up a long time ago when people had pensions that were managed by other people. Of course, today we live in a world where more and more people are running their own IRAs and their own 401ks. So my hope would be, and this is really a comment, not a question, my hope would be, sensing as I do that the average retail investor doesn't really know the difference between an investment advisor and a broker, or really note all that much difference between their IRA and their regular brokerage account, that you would help us think through how we could go to a place that just feels like a smart place to be, which is a fiduciary standard, and not have the need for retail investors to need to think that in this account, this is what my broker can do, but in this account, this is what my advisor can do. That just strikes me as complexity that we ought to statutorily do away with, and I suspect it is statutory. With respect to insider trading, Congressman Lynch and I have been working on efforts to address, obviously, the problem that arose as a result of the Second Circuit's Newman decision. As you know, the SEC and DOJ have been forced to operate in an environment where there is no explicit statutory prohibition on insider trading, leading to a body of common law that has, I think, created some odd characteristics in how one might go after insider traders. Mr. Lynch has submitted a bill. I've got one that is similar intent but slightly different in its mechanics. But I think this is important to get right. It's important to me because, unfortunately, my congressional district has been disproportionately a source of bad actors and alleged bad actors in this area. I'm a day or two, I think, from dropping some legislation that I hope you'll take a look at. But you made a comment around a similar Senate bill, and your comment was that it's critically important to investors in our markets that we have strong insider trading laws. One question I'd ask you, and then I've got a slightly more technical question, is would it be optimal if the goal here is to be very clear about prohibitions on insider trading and fairly streamlined process to actually prosecute inside traders? Should we, in fact, pursue an explicit statutory prohibition, or do you think that you can muddle by as you have under common law and the 33 Act anti-fraud provisions?
I mean, I think obviously from 10b-5 and then the common law is where we have our laws on insider trading, and I think it's a strong body of law. Obviously, we have the Newman decision that's there. I think it's challenging to codify. I mean, the Commission has also considered over its history whether it should actually, write a rule as to, the parameters. So I think it's challenging. I mean, the bottom line, which I think you were quoting from me on, is I think it's very important to have very strong insider trading laws. Now, what we're doing, as you mentioned, we filed an amicus brief in the Second Circuit. We're continuing to bring insider trading cases, including in the Second Circuit, but clearly other circuits do not subscribe to what I think is the overly narrow view of the law that in some aspects the Second Circuit has held. And so I think what we're really we're proceeding with cases in the insider trading space, enormously important to do that, and we're seeing what that ruling is in the Second Circuit. I think in terms of statutes to define it, I think that I think it's challenging to do it, but at the end of the day, what I'm for is the strongest insider trading law that we can have.
But presumably, if it can be defined in rules, as it is today, and in common law, it can be defined in statute. And presumably, also, if we're talking about sending people to jail for long periods of time, it's probably better that we do that than administratively or regulatorily we do that, no?
I mean, that's certainly an argument for doing that. As I say, I think devil's in the details maybe is not quite the right expression to apply to this, but I think it is challenging to codify it clearly in a way that is both not too broad and retains the strength of the common law. But I'd be happy to work, and have a staff provide technical assistance on that, because it's enormously important to us as well, obviously the SEC.
Yeah. Thank you. I'm almost out of time, so I'm going to have to take your answer to this on the record. But this is not a legal question. This is really a question that gets to the heart of the Second Circuit's Newman decision, which is I'm struggling to understand why the point that case hinged on, which is whether a tippee has knowledge of a personal gain on the part of a tipper, whether that should in any way, shape, or form be relevant. I understand under current common law it is, but whether it should, as a matter of right or wrong, determine whether that tippee would be liable. And I'm out of time, so we'll pursue that subsequently. Thank you. Thank you, Mr. Chairman.
Time of the gentleman has expired. The Chair now recognizes the gentleman from California, Mr. Royce, Chairman of the House Foreign Affairs Committee.
Thank you very much, Mr. Chairman. I appreciate it. Chair White, I had a question for you. But first, I'd like to thank you for the transparency the SEC provided in opening up the Office of Financial Research's study on asset management and financial stability for public comment. And I'd like to ask if you think in general that it's a good idea for the OFR to seek comments on public reports like this, and also, do you think it is important for the FIO to consult with agencies or departments with expertise in regulating financial services like your own when they're preparing public reports?
Well, I think it's very important to bring to bear the expertise that is in the space in which anybody's acting. I don't know that anyone would disagree with that. I think I can't tell another agency how they should handle their own reports. Certainly the SEC, not only are we bound by law, certainly in our rulemakings to the APA notice and comment process, but we benefit enormously from those inputs.
On a similar note, DOL has said that input from the SEC has resulted in what they call numerous changes to the proposed rule on fiduciary standards. Can you tell us exactly how many changes the DOL has made, and I'm going now to the ones requested by the SEC, trying to figure out if they're taking those changes or not, and also, are there changes that were recommended by the SEC that were not incorporated by the DOL?
I can't comment on specifics if we don't have a public proposal out there. I can say that our staff provided extensive technical assistance. We weren't in the role of a commenter, but rather a provider of expertise and market knowledge to them. I think reported back to me, I think our staff, found the Labor Department staff quite responsive and receptive to the assistance and the expertise we were providing. I can't kind of tally up, precise responses on all of those discussions. It wasn't really in the nature of providing specific comments on a proposal, but rather
there's a dialogue, but I was just trying to see if recommended changes were actually being made or not.
I mean, my sense is that certainly to a degree, the staff reported they were quite responsive to what they were providing them.
At a recent speech at Tulane University, you mentioned a recent takeover bid where we saw a unique pairing of a strategic bidder and an activist hedge fund. And in the same speech, you mentioned that highly sophisticated strategies have come to dominate proxy fights and takeover bids, but that it is time to step away from the gamesmanship and inflammatory rhetoric that can harm companies and shareholders alike. And that sounds like good advice to market participants. I was going to ask if you could expound on your comments, and specifically, I'm interested in when the gamesmanship and rhetoric crosses the line into market manipulation.
Well, that is obviously a facts and circumstances situation. I think, and again, I was obviously expressing my own personal view on this. I think I do think a step back from the rhetoric and the gamesmanship would serve everybody very well on all sides. I think that you've had at least maybe even beyond the beginnings a little bit. I think a very positive development in terms of companies engaging with their shareholders. I mean, including activist shareholders in some situations, which I think can be very constructive. So that was I wasn't talking about any individual or situation, but that just sort of overlay, I think, is a very constructive one.
Well, Chair, Mary Jo White, I want to thank you again for your testimony here today, and Mr. Chairman, I'll yield back.
Gentleman yields back. The Chair now recognizes the gentleman from Delaware, Mr. Carney.
Thank you, Mr. Chairman. Acting Ranking Member, Madam Chairwoman, thanks for coming in today. I'm always impressed with your testimony, your attempts to be very straight with us and frank, and we certainly appreciate it, I think, on both sides of the aisle. Most of my questions have been addressed, but I'd like to touch on a few of those, if I can, in my 5 minutes. Mr. Duffy and I, just to illustrate some of the bipartisanship here, worked together on the tick size pilot, and we know you're moving along with that. You answered the questions that he asked. I'd just like, a brief update on when you think we could have that in place, number one, and what's the major concern? I mean, one of the things that we tried to work through in designing it and getting input was how to structure it so we got really good information. The objective of it, of course, is to get more attention to the smaller issue stocks.
So I think that, and again, I think it's an enormously important pilot to proceed with. I'd mentioned before that I think May 6th is the date on which the Commission needs to act on it in terms of.
When you say act, you mean approve to go forward with it, to not, or?
Yes, in whatever form is, obviously we've gotten comments on various features of it. Those comments are being studied very carefully. Two of the major areas of comment, there were many, frankly, or not many, but certainly several. One was the Trade At feature, where we got a lot of comments. The length that I was discussing with Congressman Duffy as well. But our goal is to get maximum information so we can actually gauge whether increasing these tick sizes, will help.
Yeah, some of the commenters have kind of prejudged it, right, and said that it's not going to be effective. Well, let's find out, and get good information, as you said. So we would encourage you to move forward with that. We've also been working just learning more about venture exchanges, and I've talked to constituents in my district, some of whom have expressed some concern about that. These would be people that work for large institutions, concerns about maybe fraud. They had some issues with that in Canada. What concerns would you have? Could you share those concerns with me as I continue to look at this issue?
Yes, and I think the venture exchanges are also something we're seriously looking at. Obviously, no decisions made as to whether to proceed or how to proceed. We have approved prior venture exchange applications. But I think one of the reasons that at least is pointed to for the failure in Canada is who are you actually having trade on those exchanges? Is it a race to the bottom, which you do not want?
Right.
And so when you're setting your listing standards, even though they're not as high in some ways as on the major exchanges, you want to make sure that you're setting them where they ought to be set and you have the disclosures that you need so that you're not setting yourself up for failure and fraud, frankly. So those are issues that you do have to bore into when you're designing this.
Great. So you've heard a lot on the fiduciary rule from various members. I'd like to associate myself with the comments that Mr. Himes made. And what is your overall objective there in striking a balance between, the various, folks weighing in?
And again, as I say, we're kind of, this is it's a complex, challenging rulemaking. I mean, the objective is that if you are providing whatever your title is, investment advisor, broker dealer, personalized securities advice to a retail investor, that you act in the best interests of that investor without regard to your own financial or other interest. Now, that's right out of 913 in Dodd-Frank. That's kind of the beginning, of the rulemaking. You've obviously got to specify, how do you define that standard? What kind of standard is it? What does it require? How does it impact on, current business practices? And clearly, you get parameters in 913 that say, that principal transactions and being compensated transactionally are not in and of themselves a violation of a fiduciary duty, and you want to be sensitive, and indeed Dodd-Frank directs you to be sensitive to the existing business models. So as I was mentioning before, you don't end up striking the wrong balance here.
It strikes me that that's the biggest challenge. Is that kind of your sense of it too? I mean, in terms of the existing business models out there, and it's one thing to have transparency. Look, I know what I'm getting into with this product or with that product, but that's, as Mr. Himes, I think, accurately pointed out, I don't know that we differentiate very well among the various products that are out there.
No, I think, there are a number of challenges, but I certainly think that is a primary one.
And finally, I'd just like to, again, associate myself with the remarks of Mr. Lynch and the seriousness with which you took his comments. I think very important issues that you've got a lot of important things on your plate. We appreciate your great work on each of them. Thanks.
Thank you.
Gentleman's time has expired. I'm now in the uncomfortable situation, Madam Chair, of recognizing myself. I can assure all of my colleagues that before he stepped out, he handed me the piece of paper that said I was up. So if you have Mr. Schweikert, I'm looking at you. It's not my fault. So I recognize myself for 5 minutes. Madam Chair, thanks again for doing this. I want to follow up on a question or an exchange you had with Mr. Naugabar from Texas earlier today. He asked you about concerns regarding liquidity in the bond markets, and you had indicated, rightly so, that you had recently issued guidance on that topic. I actually have the guidance, or at least I have guidance that the SEC issued in January 2014. I'd like to read that to you. Take just a second. It says, while assets in bond market, mutual funds, and ETFs have grown rapidly in recent years, dealer capacity in the fixed income markets appears to have undergone fundamental changes. Primary dealer inventories of corporate bonds appear to be at all-time low relative to market size. This apparent reduction in market-making capacity may be a persistent change due to the extent it is resulting from broader structural changes, such as fewer proprietary trading desks at broker-dealers and increased regulatory capital requirements at the holding company level. So given the fact that everybody seems to acknowledge there's concerns regarding liquidity in the bond markets, and given the fact that the SEC's own guidance, which you correctly pointed out to Mr. Naugabar earlier today, names increased regulation as one of the causes of that liquidity concern, What are you doing to lessen that burden at the SEC?
I think 2 points there. One is I don't think those were findings, but clearly informed observations. I mean, I'm not trying to, split hairs, right?
I won't put words in your mouth. I'll just tell you what the document is. It's the January 2014 SEC Division of Investment Management Guidance Update.
Yes, absolutely. I'm familiar with the document. All I'm saying is I don't think there were findings made as to precise causes, but nevertheless informed statements, I think, about what the current state of play is on the regulatory side and in the marketplace. So I mean, but I think in terms of so first, I think you have to identify what actually is the cause.
Well, let me ask you this, and again, I don't want to interrupt, and I apologize, but do you agree with the guidance update that says that increased regulatory capital requirements at the holding company level contribute to liquidity shortages, not shortages, but lack of liquidity in the bond markets?
I certainly think that is the working assumption, if I could say it that way.
Is it your working assumption?
It is certainly part of the working assumption. And again, I wasn't trying to split hairs. Okay.
So tell me.
So I mean, I think there are obviously other. We control some spaces of regulation, and we don't control other spaces of regulation. That's point one. Point two is that there are various purposes and impacts in regulations. And so, one has to decide, even if you come to identify a cause that is hampering liquidity, what are you gaining by that particular regulation? So, I mean, I think it's again, I hate to use the word complex again, but I mean, I think there are trade-offs there, I guess is a better way to say it.
Everybody on this committee recognizes the fact that there's multiple layers of regulation and multiple layers of agencies that have oversight over various institutions. Have you shared that opinion and the opinion contained in the guidance update regarding the regulatory effects on liquidity in the bond markets with the other members of the FSOC?
That's been discussed extensively at FSOC.
And can you give us an interpretation as to what's going on?
I mean, what I would say is, I mean, and again, FSOC's primary purpose is a really important one, is to obviously, be focused on risks that are emerging and addressing those risks. And I think across the regulatory space, this probably is internationally as well as domestically, there's a concern about liquidity and particularly, obviously, of interest rates.
Is there a concern about overregulation?
I think there is certainly a concern about the effects of regulation. In other words, when in a number of ways. I mean, I mean, one of the risks that's identified in the FSOC annual report and has been, once you sort of regulated in one strata of the market, be it a bank, let us say, where does that activity migrate is sort of, I guess, the operative word. And then what do you do about the risk that's there that's not controlled? There's certainly that kind of lens that's being applied.
Thank you for that. I'm going to take my last 45 seconds and completely change topics on you, something that was near and dear to my heart, something that many of us worked on, not only in this committee, but in a couple of other committees over the last couple of years, which was the Jobs Act of about 3 years ago. A big part of it, something I was very excited about, was crowdfunding. You all still haven't done the rules. It's been 3 years. Can you tell us when?
Yes. I mean, can I tell you when? I can tell you that it's a high priority to get done this year. It's proved, I mentioned a little bit earlier, proved more complex, even though we knew it would be complex to get it done, so it's workable and still carries out the statutory requirements.
There have been some public comments in the markets that perhaps crowdfunding is dead, crowdfunding is not going to proceed. Would you like to take this opportunity to assure folks that crowdfunding is very much alive?
Very much alive at the SEC. I had a very extensive meeting with the staff yesterday on that very subject.
Thank you, Madam Chair. I appreciate that. And I'll yield back the balance of my time and recognize now the gentlelady from Ohio, Mrs. Beatty, for 5 minutes. Oh, I'm sorry. Mr. Sherman stepped in. I apologize. Mr. Sherman, unless you want to give your 5 minutes to Mrs. Beatty. Mr. Sherman can be recognized for 5 minutes.
You okay? Okay. Thanks for being here. Going to ask you about FASB and its lease accounting. Going to ask you about the Franken-Sherman amendment. Did that last time you were here. Not pulling any punches, but not necessarily getting great. Okay, last time I asked you, you said you were aware of the proposal still kicking around the Financial Accounting Standards Board to add $2 trillion to the balance sheets of American business, and the terrible impact that would have not only on the companies that you regulate, but many private companies as well that would be in violation of their loan covenants. FASB is, in effect, empowered by the SEC, and you were courageous enough last time, courageous may be overstating it, you stood up last time and said your agency has to take responsibility for what they do since you've empowered them. You also said at that time, I probably ought to give you a further response for the record. Don't have that one yet. But what has the SEC done since last time we talked to see whether the power that you've delegated to the FASB won't come down like a ton of bricks on small companies and on real estate and on the many people engaged in construction?
And if I owe you a response, I'll figure out what it is and give it to you. I apologize for that. And I know we've had a number.
You just owe me a clear statement to the FASB that if they go forward with this, you'll find somebody else to empower with this authority.
I mean, this is one, and I know we have had this aspect of the conversation before, where it was actually the SEC staff, I think in 2005, that suggested that FASB undertake this standard setting to capitalize leases.
That makes you even more responsible for the disaster that loomed.
I'm saying that I think, and again, all the considerations that you voiced and continue to voice are things that we certainly have bored into. I've talked to our new chief accountant about them, but it's one where we may not agree with each other on at the end of the day.
Have you, I mean, it's one thing to say, I checked with the chief accountant and he thinks that there might be some theoretical argument in favor of what they're doing. Do you have any economic studies that refute the ones that I've brought to your attention that says this is an economic disaster in the making?
Again, I haven't seen studies that refute that, nor have I seen studies that set forth that thesis.
I've provided them to you and will provide them again.
No, and I should respond to those on the record, and I will, and promptly, but because
last time
we have bored into this quite a lot, and I think I want to make sure I've answered all the questions, even if we, at the end of the day, don't agree on that analysis.
Well, I'd point out that while there may be some angels dancing on a head of a pin theoretical reason for what they're doing, and I think they're wrong on how many angels can dance on a head of a pin. I'm the only person here that actually enjoys accounting theory. But the fact is that if you look at how they've treated research and development expenses, you see they don't stick to accounting theory except when they want to. And so they violate accounting theory to destroy one part of our economy, namely, not destroy, but significantly hurt one part of our economy. And then we have to spend billions of dollars encouraging research through a tax credit because FASB departs from accounting theory and discourages research. And now, in the name of an accounting theory that they're wrong on, they're going to have a devastating effect on two other segments of our economy. And you can't just say you'll look into it, and the chief accountant assures you that he's bored into it and he likes what he's doing. We need to know that your agency will be a force for good in this area of our economy.
What I can assure you is that the meetings I have are you okay with it? I mean, I do bore into them.
Well, since you've bored into them, can you tell us why we should capitalize leases if that means that tens of thousands of businesses will be in violation of the loan covenants and hundreds of thousands of construction workers will lose their jobs?
Again, I think there are different views on the extent of that impact. I also think there are transition periods that can be applied to minimize the impact.
The transition period is way too short for the small businesses, and the effect on construction is unchallenged by any other economic analysis. I'll get you the studies again. Thank you.
Time of the gentleman has expired. The Chair now recognizes the gentleman from Kentucky, Mr. Barr.
Thank you, Mr. Chairman, and thank you, Chair White, for your service and particularly your participation in prosecuting terrorists. Today I'd like to focus on the work of the Office of the Chief Accountant to follow on the accounting theme, and then if we have time, get a little into the risk retention joint rulemaking. With respect to the Office of the Chief Accountant, I'd like to focus on public remarks that you made and other SEC officials made suggesting that the SEC is considering requiring American companies to transition from GAAP accounting to international financial reporting standards.
In particular, IFRS does not allow the use of last in, first out accounting, as you know. And in contrast, the U.S. Tax Code requires the use of LIFO for financial reporting if it's used for tax purposes. My concern is that if U.S. businesses are required to use IFRS, the International Financial Reporting Standards, they would be forced out of LIFO accounting and would be subject to a significant recapture tax that could drive them out of business or force them into debt in order to pay the tax. And this is of particular concern to industries like the bourbon distilling industry in my home state of Kentucky, inventory-intensive businesses. Effectively, the SEC here would be changing tax policy excuse me, without congressional approval. So the question is, are you aware of this potential impact of moving toward IFRS? Has the SEC considered the costs of transitioning to these international standards for industries and businesses that use LIFO accounting?
I am aware of the issue and clearly have considered, I think, the range of issues, including those cost issues and, frankly, the legal issue as well, because it's an IRS set of rules as well. But just to be clear, what I have said publicly about this, the broader issue, is that and I still believe this should occur, the Commission should make a statement as to where it is with respect to domestic issuers and IFRS. Where are we in that sequence? Last time the Commission spoke on that was 2010. Clearly, I think, certainly I'll speak for myself, I have the overall objective of, a single set of high-quality global standards, but that's the objective. In terms of, did not mean to imply there's going to, what the statement will be, would be a movement in that direction.
In your prepared remarks, you do reference Commission staff continuing in fiscal year 2014 to monitor and support the activities of FASB and the IASB as they made progress to converge gaps.
Yes, absolutely.
With IFRS. And so my question is this transition a priority? How much of a priority is it with the agency? And is a rulemaking forthcoming?
Well, I think I can't speak precisely to the rulemaking. Our chief accountant, as you may know, on his own behalf, not on my behalf or the Commission's behalf, spoke on this subject, I think, in December at the ICPA, just in terms of some thoughts he has that he may want to present to the Commission. But it is, in terms of where we are with respect to the broader issue, we certainly do support the further convergence efforts of IASB. When I say we, me, but I think the Commission supports the further convergence efforts that are going on. That's a different issue than do domestic issuers report in IFRS, which we've made no statement about at all.
I'd encourage you all to consider the LIFO impact on American businesses as you look at that issue. Really quickly, transitioning to the joint risk retention rulemaking. As you know, collateralized loan obligations are actively managed funds that invest in senior secured commercial and industrial loans to American companies. This is a $300 billion market. As you consider the SEC's very important statutory mission to facilitate capital formation, I'd be interested to hear your take on why the joint rulemaking did not carve out a safe harbor for qualified CLOs in the same way that regulators have carved out a safe harbor for qualified mortgages, especially considering that mortgage-backed securities were the principal cause of the financial crisis. And we know that the cumulative impairment rate for CLOs experienced over the life of the asset for the last 17 years, according to Moody's, has been less than 1.5%. In fact, CLOs performed very, very well during the financial crisis. Why are regulators and the SEC in this rulemaking not taking that into account, especially as we talk about liquidity and capital markets and corporate bonds? CLOs, another important source for financing. Why are the regulators not taking that into account?
I think that's an issue we spent a lot of time on in the joint rulemaking. I think the conclusions are set forth in the release, but I can certainly expand on that in getting back to you.
Well, thank you. I yield back the balance of my time.
The gentleman's time has expired. The Chair now recognizes the gentlelady from Ohio, Ms. Beatty.
Thank you, Mr. Chairman, and thank you, Chairwoman White, for being here today and answering a whole broad array of questions. My question will reference something that you mentioned not only in your written testimony, but earlier this morning, now afternoon. I think I can bring it up again. When you talked about advancing opportunities to small businesses to raise capital, certainly as we know, small businesses together produce a lot of the economic growth. While I hate to hone in on anyone specific, I think if we don't, oftentimes when we represent those groups, others might not. So as people give examples from their districts or from letters or stories that they've received, I'm going to focus in on women in particular. Certainly looking at your background, having many firsts prior to coming here, and being the only female sitting here on my side of the aisle today, and looking at my colleague, Congresswoman Love, being the only female on her side of the aisle, I think I might have something we can agree on here. So when you talk about advancing opportunities, and you also mentioned the SEC's Government Business Forum, I guess one of the questions I want to ask is, can you address what specific types of opportunities that your office is doing for businesses in general and women? And another reason I'm doing women, just this morning I received some statistics, and I'm from Ohio, 7th largest state in this nation, and there are 16 of us in our delegation, and I have the largest number of females in my congressional district. So today I speak for them, and it happens to be the end of Women's History Month, so maybe you can help me out by giving us some information that we can use or help you with.
First, I applaud everything you just said on behalf of women. I think, I mean, one example I would give you where I'm actually rather pleased with the results is actually through our OMWI office, where one of the charges OMWI has is with our own contracting dollars. I mean, it's $350 million a year or whatever it may be. We are charged with making sure that we are making possible for minority-owned businesses and women-owned businesses to participate in the process of our the contracting that we do. And we've actually, I think, in fact, I think I brought the number with me. I think 33% of our contracting dollars actually went to minority and women-owned businesses last year, which is a real uptick from all our outreach efforts. We try to also have, I think it's once a month, that our office actually has potential vendors come in, potential businesses come in to kind of learn what they need to do to, in effect, bid on those contracts, apply for those contracts. I think, to broaden it out beyond that, but I think that's a kind of a good example. That's at least I'm pleased with the progress that we've made on it. When we are dealing with our our small business committees, when we the office I mentioned earlier that's in our Division of Corporation Finance, it's devoted solely really to the interests of small businesses. We certainly are very focused on encouraging women-owned businesses, minority-owned businesses to participate there. A lot of the questions that our staff answers, which they do, I don't know, 1,200 a year from small businesses, are questions put to us by minority and women-owned businesses. So I don't know if that's responsive, but that's a couple of examples at least.
Thank you, and thank you for the examples. Maybe we can pass some of those on to some of the other offices who aren't doing as well. Lastly, I met with some constituents who have expressed some concerns about the effects of applicability of the fiduciary standards being applied to broker-dealers. In your written testimony, you stated that the Commission has provided technical assistance to the DOL staff as they consider potential changes to the definition of fiduciary under ERISA. How do you see SEC interacting with the DOL to ensure that low and middle income individuals keep their access to broker assistance regarding investment of retirement savings? I
think first, with respect to the Department of Labor, what our staff has done really for several years is to provide technical assistance and expertise to the staff of the Department of Labor. And what's included in that is our judgment from our knowledge of the broker-dealer market spaces in the retirement area in particular, how a change in the rule might impact on investors or the availability of investment advice separately, and it really is separately. We are proceeding, or my personal view is that we should proceed with a rule to impose a uniform fiduciary duty, but very much in our minds in doing that are all the complexities and all the impacts. And what we don't want to do is end up with anything that would deprive retail investors of reliable, reasonably priced advice. Okay.
Thank you. My time is up. Thank you, Mr. Chair.
The time of the gentlelady has expired. Chair now recognizes the gentleman from Arizona, Mr. Schweikert.
Thank you, Mr. Chairman. And Madam Chairman, I go through the same thing, isn't it? It's just hell having multiple. Many of the questions I wanted to ask have already been asked, but I want to go back to both Representative Velasquez and Mulvaney. We asked you about crowdfunding. I was gone for 2 years. Now I'm back, and I'm having the same conversation even with you when you were kind enough to come talk to me when you very first were appointed. What was that, April 2013? And love a little bit of information to understand some of the rulemaking process, the political influence, the outside group influence. Why are we years behind on those rule sets from the Jobs Act, both for crowdfunding particularly, and then the enhanced Reg A? I mean, we're what, two plus years behind the deadlines?
Actually, Reg A didn't have a deadline, but it's a high priority, and we may actually move on that as fast as
But 2
tomorrow.
years ago, you used that exact same
Yes.
line with me that it was
I
a
did.
high priority.
And it was and it is a high priority. I think let me talk about crowdfunding. I talked a little bit earlier about that. I mean, again, excitement. I think one of the things I did when I first arrived, because we had not proposed the crowdfunding rule, we had not proposed the Reg A plus rules. So I prioritized, having them proposed. Then you have your comment period. We've gotten a lot of comments on the crowdfunding rules. I think over 500. Most of them unique comments on all sides of the issue. You don't have enough investor protection in it. It's not workable. It's too costly. This is one where we knew it was going to be complex. We have the funding portal piece of that we're working very closely with FINRA on. But essentially, in order to be true as we must be to the statutory requirements, the costs, and the workability, it is proved more difficult and taken longer than we anticipated. I mentioned earlier that I actually had a meeting yesterday at some length with the staff to move.
Madam Chairwoman, to this point, would we help you help the public if we'd be dramatically more prescriptive when we pass legislation? If we did self-executing deadlines and started to force these rule sets to actually happen, if you and your organization aren't able to finish their work, we know where we are? Because right now we have how many states that are doing state-based ones? So you do have incubators and examples out there, so you're not recreating the wheel. What am I not understanding?
I think the challenges vary in terms of being less or more prescriptive. I mean, some of the challenges for us are created by the prescriptions, because if they're prescriptive, we need to carry them out. And so I mean, I think that as we've been calling it, more technical assistance before the legislation is passed. I think that's on us to be more interactive about it as well, because what we're trying to do, a baseline, I don't mean to use that in the economic analysis terminology, but a baseline for us is to carry out the statutory mandates. But sometimes those mandates are hard to carry out.
But you can understand from my side sitting here, in much of the rest of the world, our industrialized world, there are crowdfunding platforms. And for some reason from, conception to today, I'm, 3 years? And a couple years behind on the rule sets. It's just because we hear lots of speeches around this place from many of us saying, we need to be helping the little investor. We have income inequality. We have actually what we seem to have as an opportunity gap. Oh, here's a way we're going to help that entry-level entrepreneur. And we sit here a couple of years later, so you can understand the frustration. One sort of side question. with the number of states that have gotten frustrated and just said they're going to do it on their own, will the SEC step in their path if Arizona decides to work with Texas and recognize each other's platforms? Will states be allowed to sort of set up state compacts?
That's one set of issues that we now have because the states have proceeded, and that's not at all a critical remark. I mean, I think they
didn't have a choice.
No, but clearly, I think there's a benefit of a national rule. But once the states have moved constructively, as many of them have, I mean, what you want to try to do is accommodate as much of that as you can.
Okay. Thank you, Mr. Chairman.
Chair now recognizes gentleman from New Hampshire, Mr. Ginta.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, for being here today. This line of questioning has been discussed in the last couple of hours, but I want to go back to it because I still didn't quite hear some of the answers that I was hoping to hear. And it goes back to the fiduciary duty on broker-dealers. I know it's been stated that back on February 20th at the SEC Speaks conference that you noted one of the priorities would be for the SEC to determine whether to adopt a uniform fiduciary duty for broker-dealers. And then obviously a month later, approximately on March 17th, you had stated that it was your personal view that that should be done. I'm still trying to understand what happened in that period of time where it appeared things changed. And I was here for most of your testimony, but I didn't hear a very specific and clear answer.
The answer is that nothing really changed other than I had another month of study. I mean, I've been studying this issue in great depth for many, many months. The reason I phrased and it frankly is still a weather question because it's up to the Commission. I'm one of 5 votes on that Commission. But the statutory authority is we need to make a decision whether to proceed, and then obviously, if so, how to proceed. But this is an issue that grabbed my attention, for want of a better expression, before I was confirmed. I basically, and I said it earlier, when you have essentially identical conduct regulated differently, particularly in the retail investor space, you got to think long and hard about why that regulation shouldn't be the same. Now, okay,
so you mentioned that there was some analysis you relied on. Can you tell me what specific analysis and study you relied on?
I mean, it's really the body of analysis that's been done over the years at the SEC by various outside groups who've been studying this. Our economists continue to study it as well.
Would you provide those analyses to me and the committee? And then can you tell me what specific analysis you can point to that predicts the impact of the uniform duty for low and middle class families?
I mean, I can't cite the particular studies that are that touch on those issues. I mean, clearly there's more data that our economists are focusing on, on issues including that one. But I can certainly include in the list the ones that touch on that.
Do you know what analysis estimate if they estimated the impact would be on women and minority investors?
I mean, again, there are several analyses of kind of running the gamut in terms of what methodology they use that talks about.
Did that go into your decision making in that month?
I mean, all that I studied did, and just in terms of rulemaking, if we advance it, inputs from all sources, including our own economists, will go into that.
I think this is important because both sides have talked about this. Was there any analysis that you relied on that predicted what, if any, negative impacts there would be for investors that were valued under $50,000?
There absolutely are, studies, articles, academic papers on that I've looked at.
Was there something specific that you relied on when you made this final decision?
I mean, essentially what I relied on in reaching the view that I have at this point, my personal view, is the full body of evidence that is before the SEC. It's not just the SEC's studies, although that's included in it as well.
So the potential increase of broker commissions as a result of this was a consideration?
I mean, anything that impacts on are you depriving retail investors of reliable, reasonably priced advice? is a very important consideration.
Was there anything specific about whether proprietary products would be considered, continued to be offered to customers?
Again, 913, Dodd-Frank Section 913 specifies a number of parameters,
But I'm
including
trying to get to the analysis. The analysis that you utilized, that you said you utilized, were these items things that you specifically considered? I know
don't know how else to say it other than I
exist generally, but I'm trying to get to whether you specifically looked at these analysis and did they have a determining factor in moving forward with this
I mean, it's hard to say what moves you to your conclusions, I guess, but what I did was the deepest and broadest dive I could do before formulating my own personal
All right.
view.
Well, I've heard the broad. I need the deep. That's what I'm looking
Okay.
for.
I think, again, I think I have to, provide you with the sources. The only way I know to answer that.
Would you be willing to provide communications that you had between February 20 and March 17 relative to this rule?
Yeah, but I don't think you'll see anything. I mean, in terms of, you mean like emails or something?
Written, email, absolutely, yeah.
I mean, I'll obviously take it back to the folks of the SEC, but I mean, I'm happy to provide whatever you need, frankly.
Okay. Well, I'd love to see those communications. That'd be great. Thank you. I yield back.
Time of the gentleman has expired. Chair now recognizes the gentleman from Texas, Mr. Williams.
Thank you, Mr. Chairman, and thank you, Chair White, for being here today. I'm a small business owner. I live in Texas. Now, last year you testified that the markets are not rigged. In July of 2014, a staff member from the Federal Reserve Bank of Chicago issued a research paper titled Recommendations for Equitable Allocation of Trades in High-Frequency Trading Environments. Now, first question, are you aware of this paper?
I do recall the paper. It's a year ago, right? Approximately, yeah.
Right. A second question, does the Federal Reserve Bank of Chicago have any regulatory responsibility for the conduct of equity markets?
Not to my knowledge.
Did you ask Chair Yellen or the President of the Federal Reserve Bank of Chicago to write this paper?
No.
And has the staff of the Division of Trading and Markets analyzed the paper's 9 recommendations? And does the division have concerns with any of the recommendations?
The answer to that is certainly to a degree the staff analyzed it because I asked the staff about it, and they had a number of comments about it. I can't give you the details. I sit here right now, but certainly they have analyzed it.
You have any concerns?
About the study or about the?
Well, with some of the recommendations.
I think the answer to that is yes, but I have to get back in and look at what that is so I can be more specific for you.
I think we'd like to hear what they are.
Happy to do it.
All right. Just last year, a second question, just last year you stated that the SEC owes a duty to Congress, the staff, and the American people to use the funds we are appropriated, that we have to be prudent and efficient. Now, do you believe the SEC has a responsibility to demonstrate that it is a good steward of its current resources before it asks for additional funding? And I'm always amazed as a private sector guy how we just have unlimited money up here, that the unlimited line of credit, just drawing the people's money till it dies. So with that, before you answer that, I will note where I come from in Texas. My constituents are not overly concerned about the rules, for instance, that we've talked about earlier that deal with the CEO pay ratios, which the SEC spent over 7,000 staff hours and $1.1 million in labor costs for a rule that we don't even have implemented yet.
I think all I can say in response to that, and I alluded to it earlier, I think, as well, is that is a congressional mandate, as are many of our other rulemakings, that I do feel an obligation to carry out and carry out in the most cost-effective way, given the statutory requirements. Clearly, there are cost and workability concerns in that rulemaking that require a lot of staff time in order to achieve that objective. So, I mean, I think that's the explanation. It is the explanation for the resources that have been applied to that. It's a congressional mandate, and we want to carry it out because it's our obligation to, but do it in the most cost-effective way we possibly can.
Next question. Earlier this year, J.P. Morgan Chase indicated it would cut back on its fixed income trading desk because of the regulatory requirements and capital costs following the lead of what other investment firms are doing. Are you concerned about these new regulations, that they are reducing liquidity in the U.S. fixed income market?
I mean, I have a concern about all impacts, including those that are being occasioned by regulation.
regulations are killing small business. I would just tell you that. They are choking it to death. One more question. Last week, the SEC lost a case that it ran through its administrative hearing process. The administrative law judge called the SEC's claim wildly exaggerated. Will the SEC enforcement staff who did this, who received bonuses for bringing that case, will they have to pay them back? You know, because I've listened to your testimony today that you're short of funds to get the job done. If they paid that back, that would help your cash flow, wouldn't it?
I guess I have to say at the outset that that case may come to me on appeal, so I can't really talk about the specifics of it. We're also limited by various civil service rules and other things in terms of what we might be able to do in that space were we to take a decision to do that, but I'm not commenting on the merits or demerits of that situation.
Well, right now it's been deemed wildly exaggerated.
I heard that.
Mr. Chairman, I yield back.
Gentleman yields back. Chair now recognizes the gentleman from Colorado, Mr. Tipton.
Thank you, Mr. Chairman. And Chair White, thank you for taking the time to be able to be here. I think many of my questions have probably been answered. But just to follow up, quoting you, you just talked a little bit about confusion is not a good thing, and that we think that we are doing good cost-benefit analysis. And I'd like you to expand on that for me. I understand your charge is obviously safety, soundness, to make sure we've got good markets that are moving forward. But talk to me a little bit about that cost-benefit analysis, because right now we are seeing $2 trillion a year nationwide in terms of regulatory compliance in this country. I share common ground with my colleague out of Texas, Mr. Williams. I'm a small businessman. We're seeing more small businesses shut down than there are new business startups. So while we want to be able to have those cost benefits, let's look at outcomes. Is the economy really moving? We've got the lowest labor participation rate in 37 years right now. Are we stimulating the economy, creating that opportunity for America to be able to succeed?
We certainly want to be doing that. I will say, just in terms of the small business space, the small cap companies, as we would call it, the SEC, I really have tried virtually from the month I arrived here to focus on that space. One size doesn't fit all, and that probably applies across all kinds of spaces, but including our equity market spaces. That's one of the reasons we're doing the tick size pilot. When it comes to cost benefit, we certainly do that analysis with respect to all of our rulemakings, including those that are mandated.
When you're talking about benefit, what do you perceive as benefit?
Well, the range of benefits. I mean, the range, benefits. Does it protect investors? Does it facilitate capital formation? Does it prevent the next financial crisis?
Formation?
I'm sorry, say again?
Have we succeeded in capital formation?
Well, we're certainly devoting a lot of effort to trying to succeed there, but obviously there are things in the marketplace that I think are impediments to that.
You know, I just visited when we're talking about some of the rules and regulations that are going on. It was some of the stress tests that are going on for banking institutions. Last year, one of the regional banks in the western United States had 7,000 pages to be able to complete the stress test that had been submitted. This year, it was 12,000 pages. Is that complexity, is that cost, is that impact? Because obviously the bank has to be able to take that into consideration in terms of its ability to be able to have capital, to be able to issue loans to the small businesses that you're talking about wanting to be able to help. What's the thought process there?
Well, I can speak from the perspective of the SEC that one of the things that we really do bore into when we're doing our rulemakings is not only the Paperwork Reduction Act, but obviously the impact of administering whatever the rule is, on who it's going to be imposed on. But I take your point, obviously.
Yeah, we haven't succeeded too well when we're going from 7,000 to 12,000 pages in paperwork reduction, obviously. I'd like to talk just a little bit to shift gears. You're talking about the mission of the SEC, but under Dodd-Frank, it requires the FSOC to do an analysis before it determines a particular financial institution becomes a SIFI. However, the SEC, Treasury, Federal Reserve are members of the Financial Stability Board, and you participated in the designation of insurers like Prudential and MetLife as SIFIs prior to considering the same issues under the Financial Stability Oversight Council. Presumably, a prior decision by the FSB would taint any decision that's going to be coming out of the FSOC. And could you explain to me how you're going to be able to avoid some sort of a conflict of interest in terms of pre-designating, if you will, when it goes through the FSB, then to the FSOC, and it happens?
As I mentioned earlier, I didn't actually participate in all those decisions at FSOC, but I did with respect to MetLife, as I think I mentioned before. The SEC's role on the FSB, which has been in existence since 2009, along with Treasury and the Fed as the 3 U.S. representatives. Our staff, basically, as a matter of practice, does not participate in work streams that are solely related to insurance or non-securities areas.
I guess actually my point, Chair, is
so some of those
seems like
decisions
the
don't come to us.
FSB makes a pronouncement and it just flows down. I'd like to be able to see some of the independence that is coming through. Can you speak to that?
I can certainly speak on behalf of myself, and that I'm totally independent. I think when it comes to, I hope when it comes to any decision that I take, and certainly were the FSOC to take some action. Again, this would be a space at the FSB I wouldn't be participating in, so it's not a that kind of a direct connector. But it's up to the national authority to be defined, probably, but as to what we do domestically. But I feel like I'm an independent decision maker.
Time of the gentleman has expired. The Chair now recognizes the gentleman from Maine, Mr. Poliquin.
Thank you, Mr. Chair. Thank you, Chair White, for being here today. I appreciate very much you coming before us. We all know that America's free market capitalist system has produced some tremendous lifestyles and standard of living for millions of Americans, generations past, and pulled so many people out of poverty going forward, and not only in America, but different parts of the world. It also provides us with the tax revenues we need to defend ourselves and to take care of the poor that really need help. Now, the bloodline of our economy, as you well know, Chair, is in part the financial services industry and the capital markets. Because if our small businesses are unable to raise capital to expand, then they have a problem being successful in hiring our people and providing better lives for everybody. Now, in the 2008 recession that hit, that was caused in great part by the collapse of the housing market, the result of that, in part, was a wide net Dodd-Frank regulations that now has been expanded, it seems like, more and more over our entire financial services industry. And one of the results of Dodd-Frank, of course, as you know, is the Financial Stability Oversight Council, on which you sit. And you folks are responsible for designating which financial institutions here in our country are systemically important financial institutions, or FSOCs, excuse me, or SIFIs. Now, a great concern that I have, Chair, is that in our mutual fund industry or pension investment industry, the money management business, I'm very concerned that this wide net of Dodd-Frank is now about to engulf them and designate them as SIFI organizations. And here's why I'm concerned. If there were 2 money managers, and they're both managing, pick a number, $100 billion for their clients, and this manager has poor performance for a period of time, this manager has better performance for a period of time, then this manager is going to be fired and the clients are going to go over here. But all the assets that they run are housed at a trust department down the road somewhere. So there is clearly no systemic risk to the economy or to the capital markets by these investment management firms being designated and so regulated as SIFIs. So my concern is that if you have a middle-class family up in Ellsworth, Maine, that I represent in our 2nd district, and you have a paper maker from the Bangor area, and his wife is a teacher, and they're putting aside $50 a week to save for their retirement. And they want to have a nest egg at the end of 20 or 30 or 40 years of working very hard in their professions. But all of a sudden, if you have these investment companies that are helping their nest egg grow such that they can retire in dignity without being dependent on the government, if we cast that net, Chair, over these pension investment firms, these mutual fund companies that represent no risk to our capital markets, no risk to our economy, I'm fearful that the products they'll offer will shrink, and the fees that they charge will go up, and then the rates of return that they generate for their clients that are trying to save for retirement will go down. In fact, Dennis Rosk, a little bit before, mentioned a report by former director of CBO Holtz Eakin, saying that, in fact, if that happens, you could see a 25% reduction in the growth rate, the rate of return of these savings for college kids going to school or people trying to retire. So my plea to you, Chair, is that you sit on FSOC, along with Treasury, along with the Federal Reserve. You have the authority, I hope you will speak up, to make sure the pension fund business, the mutual fund business, those that are responsible for helping our families grow their nest eggs and retire in dignity, won't be held under this umbrella because it will only hurt them. Do I have that commitment from you today?
You certainly have my commitment that I will speak up on all of those issues.
I appreciate
and
it
others.
very much. And thank you very much, Chair White. I would also like to encourage you to resist any temptation from the Federal Reserve or the Department of Labor or anybody else to take the authority that you have at the SEC to regulate non-bank financial institutions. You folks have been doing it for 80 years. You have the experience, you have the tools, and I'm concerned that if these money management firms that are trying to provide savings power, if you will, for our middle-class families, if they fall under regulations or under the regulatory authority of the Fed or the DOL that has no experience doing this, it will only hurt the people we're trying to help. So I would encourage you, please, stand up, be heard, I know you will, and make sure that you regulate these money managers as you always have.
Time of the gentleman has expired. The Chair now recognizes the gentlelady from Utah, Ms. Love.
Thank you, Mr. Chairman, and thank you, Chair White, for being here today. Us freshmen really appreciate you staying and answering some questions for us, so I want you to know I really appreciate it. I wanted to talk a little bit about Dodd-Frank and then try and get into capital formations. If I can, our time is limited, so I just wanted to get through these as quickly as possible. But during the implementation or the development of the proposal to implement Section 619 of the Dodd-Frank Act, commonly known as the Volcker Rule, the banking regulators led by the Federal Reserve attempted to write a rule addressing trading and investment practices, activities that fall within the core competencies of the SEC. In your opinion, should the SEC have taken more of a leadership role in developing the Volcker Rule to ensure that the final rule was consistent with the SEC's mission and maintenance of robust capital markets?
You know, again, the Volcker Rule provided some prescriptive steps and rules that, were required under that rulemaking. It did not require the regulators to act jointly, actually. It did require us to act in consultation. We ended up, which I think is a very good thing, acting jointly. From my perspective, I think the SEC was quite active, and the staff was quite active. I was quite active in providing inputs from our market-making, underwriting markets perspective for that.
Okay.
Rule.
Would you agree that the final Volcker Rule makes it difficult for banks to buy or sell securities for their own inventory in anticipation of clients' demand because managing the inventory can look like proprietary trading?
I mean, certainly that is an implementation challenge, but obviously there are prohibitions and there are exemptions. We tried to make the exemptions as workable as possible, given those constraints. But
okay. In 2009 and 2010, as Congress drafted the Dodd-Frank Act, it rejected proposals to strip the SEC of its market oversight authority and declined to transfer the registration of investment products to what ultimately became the Bureau of Consumer Financial Protection. Would you agree that the SEC regulates markets that are inherently risky?
Yes. I mean, the markets are, built on taking risk. I mean, that's what fuels innovation, the economy. They want to be prudent risks. You want to have the disclosures you need to have, but yes.
Would you also agree that the risks taken by investors are essential to capital allocation, which in turn is critical to economic growth?
I mean, again, I think the kind of risk I'm talking about underlies our capital markets. I mean, you want to disclose to investors what they need to know.
So yes, yes, yes.
I think that's a yes.
Okay. Does the bank-dominated FSOC reject your authority to propose and possibly adopt changes to oversight of asset managers?
No. I think the answer to that question, I mean, what FSOC is doing is, at the moment on the asset managers, is requesting information on various activities of asset managers. SEC staff was, very much a part of that. We've proceeded, as I think I said earlier, with a number of, we are proceeding with a number of regulations in that asset management space. That's the SEC, not FSOC.
Okay. I have just a little over a minute, and I wanted to really get back to this because this is obviously very important to this body. We're approaching the 30-year anniversary of the Jobs Act without the Commission, without several of the major components being effective. Can we expect the Commission to finalize the Jobs Act rulemaking for crowdfunding?
The answer to that is yes.
Will you commit to finalizing this rule by the end of fiscal year 2015?
What I will say is it's a high priority and for 2015, and I had a huge meeting on it yesterday to move it forward.
You're asking for $1.77 billion, and this is incredibly important.
I agree it's incredibly important.
And I would like to know if you would commit to finalizing this rule before the end of fiscal year 15.
I mean, it is on our agenda to complete by then, and we're working very hard to make sure we can make good on that commitment.
Okay, so no commitment to do that.
My commitment is that we are according at the highest priority to get it done in 2015.
Okay. How would you respond to, okay, you know what, I'm out of time. Thank you.
Gentlelady's time has expired. The Chair now recognizes the gentleman from Arkansas, Mr. Hill.
Thank you, Mr. Chairman. Chair White, thank you for being here. Thank you for your long, wonderful service to our country. We appreciate your leadership. You made a comment a few minutes ago that said you had pride in your independence and independent thought as it related to the FSOC. And I presume that you and your fellow commissioners believe that at the SEC that you're an independent regulatory agency.
Yes, we do.
And the fact that your budget comes to appropriation before the Congress doesn't in any way limit or cause you to feel less independent, I wouldn't think.
No, it doesn't.
Thank you. My friend Rick Ketchum over at the FINRA has a proposal that I think you're familiar with referred to by the acronym CARDS, and I wonder what your view is on that.
That is, again, by virtue of the regulatory structure, a rulemaking that will come to the SEC to pass on, so I can't really comment on the merits of it. I can say I am familiar with it. I'm familiar with the many comments that have been made in response, and familiar with the fact that FINRA is, working through, taking very seriously those comments. Should they advance the rule, it will come to the SEC for approval, notice and comment, and so forth.
One thing that I think we talked about liquidity, and I think a lot of my fellow members of the committee were primarily talking about the government securities market and issues around the Volcker rule, but I want to turn to the liquidity of another market that's extremely important to millions of investors and then all of our cities and towns, and that's in the municipal finance market. And I'm interested in your views on the MSRB's Rule G23, which limits the financial advisory arms of BDs from participating in anonymous auctions for municipal securities. Can you give me your views on that?
I might have to come back in detail on that. It's one that the SEC has approved, I think, at this point. So, that is some indication of my position on it, although that's done by the staff, by delegated authority. I do think, one of the things that I mentioned at the one of the two speeches I guess I gave in June on some of these market structure issues is that I thought it was very important for the MSRB to advance the best execution rule. I also thought that it was very important for both FINRA, and the MSRB to forward what's referred to as the riskless principal disclosure rules. That entire market, I think, bears the attention and priority that it's getting now. We, again, are more limited in that space from a regulatory point of view than we are other spaces.
Well, I think, it's my view as somebody's got some familiarity with those markets for some period of time, that if one were to increase potential buyers in a competitive bid, anonymous competitive bid process, that you would increase liquidity and benefit the issuers, the public entities in the revenue or GO market, and obviously by virtue of that, the investors that buy the issue at the offering price. And from what I can tell from looking at the data, the rule, when you exclude that FA side of a BD's business, you are limiting market participants and therefore limiting competitive bids, maybe cutting them in half potentially. So I ask you to look at that from a competitive and liquidity point of view, because our capital markets in the public finance arena, we want more bidders. And our investors are benefited by having more bidders, because these are mostly long-term, as you know, buy and hold investors, and that improves best execution. So I would encourage you to look at that. Final topic I'd like to raise with you today is this issue, again, on what I've sort of described as the war on savings. And I group all these things together: the 529 proposal that was withdrawn, the DOL proposal that's in discussion, the increasing capital gains taxation, the removing of stepped-up basis, the cap on IRA accounts. Back in the ancient history when I served at Treasury, we were demanded to increase savings and to create more ways to encourage Americans of all income levels to save and improve our capital markets that way. And I would like to talk to you a little bit about the fiduciary standard and just add my views. You've heard a lot about it today. I think that there's the suitability rules that we have, the know your customer rules that we have, the elaborate performance that brokers and financial advisors go through with their clients is more than sufficient to let the customer make a decision whether they want that fiduciary relationship or an agency relationship. And I want to add my weight of my comments that I don't think there's an automatic benefit to the capital markets by going fiduciary only, and I really urge you to reconsider your thinking there. Thank you, Mr. Chairman.
Time of the gentleman has expired. Chair now recognizes the gentleman from Pennsylvania, Mr. Rothfuss.
Thank you, Mr. Chairman, and thank you, Chair White. Not only are the freshmen glad that you're sticking around, but this sophomore is glad as well, so thank you. I read an article earlier this year from Gallup called American Entrepreneurship, Dead or Alive. The article begins by stating that the U.S. ranks 12th in terms of business startup activity when compared with other developed nations. This is a pretty troubling statistic at a time when we are trying to grow the economy and create more jobs. That is where I turn back to one component of the SEC's statutory mission, facilitating capital formation. I understand the SEC held its annual Small Business Capital Formation seminar this past November. Can we expect to see the SEC taking any action on its own to move forward with any ideas raised at that forum?
There are a lot of ideas, I think, discussed at that forum, and right as we speak, the staff is analyzing those for my benefit and the benefit of my fellow commissioners.
Will we be seeing any kind of public statement about it, taking those ideas?
I think we have to complete the review and analysis of them, but I think, again, as I said earlier, I'm certainly very focused, as are a number, if not all, of my fellow commissioners, on intensifying what we can do for capital formation by small businesses. I mean, the tick size pilot, what we're doing in the disclosure effectiveness review, are examples of that. Some of those recommendations, by the way, came from that forum as well as our small business committee.
We've had some good success in Pittsburgh. It's one of the top cities attracting new technology companies in recent years. This sector is growing thanks to venture capitalists, angel investors, and others. A large part of the positive progress is related to the top-notch educational institutions in our area and local firms that are willing to support the local startups. This growth is certainly welcome in western Pennsylvania, but we need to have this going across the country. That leads me to a question about what the SEC may be doing, if anything, with respect to looking at its rules and regulations and how you're keeping those updated. Has the Commission taken steps to consolidate or eliminate rules that are out of date or ineffective?
We certainly do a retrospective review under the Reg Flex Act, and we also take input from all kinds of sources as to rules that we ought to either consolidate or change in some way.
Can you give some specific examples of some of the regulations you've taken a look at?
We basically look at them periodically if they're major rules, every year. I mean, it's sort of a rolling basis.
Is there one or two that you could highlight that?
I can get back to you on specifics and where we've moved on.
Appreciate that. Looking at the top line summary of the SEC's budget justification, there's a significant emphasis on enforcement versus rulemaking. The Commission's request states that the top priority would be to hire 225 additional examiners. This is significantly higher than the proposed resources dedicated to economic and risk analysis and rulemaking. Why is the SEC making its top priority hiring 225 additional examiners instead of the SEC focusing on furthering the delayed rulemaking process?
Well, I think to go for the economic analysis, our DERA unit, if you want to call it that, which is where it houses our economists, that obviously participates in the analysis, including cost-benefit analysis of all our rulemakings, is actually our fastest-growing division. One of the great, I think, success stories of the SEC. We've sought additional resources for them as well. I think we now have 90-plus economists, up from about 40 just a few years ago. So you can only obviously hire so many well and smartly, I think, in terms of the examiners per se. And I spoke about this a little bit earlier as well. I mean, that's an area where I think we really have a responsibility to try to meet that gap in terms of our ability to cover exams. It's not enforcement, but exams of investment advisors, for the benefit of the markets and investors.
Again, I think we're looking to, as has been said, concerned about the Jobs Act and getting those rulemakings done.
Absolutely.
You've noted previously that when disclosure gets to be too much or strays from its core purpose, it could lead to what some have called information overload. By allowing our disclosure regime to become the de facto vehicle for more and more human rights campaigns, do we run the risk of compounding the information overload problem that you previously highlighted?
I mean, I think, and again, as part of our disclosure effectiveness review, we're trying to deal with a number of those issues to make our disclosure more effective. It really isn't necessarily reducing it, but making it more effective and more investor-friendly to use.
Would you agree that this information overload in SEC filings may actually be confusing and distracting to investors who are seeking to make informed investment decisions based on material information?
The core of our disclosure powers should be directed to what's material to investment decisions and voting decisions. And certainly one of the things we look at is whether we have information in there that's distracting from that core purpose.
Thank you.
Time of the gentleman has expired. Chair now recognizes the gentleman from Illinois, Mr. Dold.
Thank you, Mr. Chairman. I certainly appreciate you sticking around. And Chair White, thank you so much for your testimony and being here, and thank you for your service to our country. This is, I think, the end. So short little time here. I do want to, well, at least for today, I hope. I want to associate my comments, first of all, with my colleague, Mr. Hill from Arkansas, and I certainly hope that we all are looking for ways to try to encourage more savings. And so his words, the war on savings, I hope that we're all looking to try to make sure that we can put policies in place that encourage more savings throughout our country at all different levels. I wanted to talk for a second about accredited investors. And certainly, the definition of accredited investor purely on income or net worth, I think, is somewhat antiquated and counterproductive. And as you, I'm sure, are aware, the United Kingdom recently added another mechanism and measurement really revolving around education. so that they actually are able to go through and take a test to be able to be considered an accredited investor. So I just wanted to say, is the division considering an educational component as you begin to update the definition of accredited investor?
Yeah, the Division of Corporation Finance, together with our economists, is doing a very deep dive into accredited investor definition and considering really kind of all possible parameters. I mean, beyond net income, net worth, sophistication, licensing, education, testing, the entire range is being considered.
Well, I certainly hope so. I mean, it seems odd to me that you could have, a law degree, an MBA, graduated from college, and just because you don't have the income or net worth, you're not going to be considered able to invest in certain securities. I wanted to also talk to you for a second about your written response in September of 2014 to Chairman Hensarling regarding the SEC's Post-Jobs Act capital formation agenda, which really didn't have a whole lot of commission-generated ideas to enhance capital formation. Beyond the congressionally mandated rulemakings in the Jobs Act, what are some of the specifics that the Commission is looking at to improve capital formation?
I guess I would mention three. I mean, I think there are more than that. And some of the Jobs Act provisions are also ones that both our advisory committees and the staff were working on as well. So I think, and they're obviously very important ones for us to finish also. The tick size pilot is one example. The disclosure effectiveness review, the consideration of venture exchanges. And then we do have our dedicated unit in corporation finance that really is focused in the rulemaking sense, in the kind of the service sense, exclusively on small businesses and what their needs are.
Well, certainly appreciate that. Being a small business owner, small business is vital to Main Street and, frankly, for job creation. I wonder if I might be able to switch to BDCs, so those are the business development companies. And business development companies have seen a fairly rapid increase in growth over the past few years, from about $4.7 billion in assets under management in 2002 to about, at least my calculations are, $73.1 billion in 2014, providing loans to small and middle market businesses. Again, going back to that idea, most of the net new jobs are created by these small businesses. This growth stems from the demand of capital that the BDCs are filling. So what is the SEC doing to help support the growth in this important industry, and in particular, what efforts are underway to modernize BDC regulations?
That is being looked at by our staff, in part in connection with at least one or more bills that I think were pending last session. So it's something that, I think there are a number of ideas that are out there, some that might give us some concern, but clearly a very important segment of the economy.
Okay, so there's
nothing imminent.
Specifics, though.
Nothing imminent. That's no.
Okay.
But I can again, get back to you with the sort of the outlines of what we're doing on that.
In a letter you wrote to the committee in October of 2013 regarding some proposed BDC legislation, you indicated that a number of those provisions in a bill, and I do believe that one of my colleagues is going to also offer some legislation. If he does, and I will. But the provisions pose you indicated that the provisions pose no investor protection concerns. These also happen to be provisions that have not been updated for 30-plus years, and you have the authority right now to modernize and fix. What have you done, or what do you plan to do to help modernize these rules?
Again, it is something that the staff is reviewing. We obviously have a very full agenda. I'm not minimizing the importance of BDCs on that, but I think I would have to really probably follow up for the record in terms of sort of where that fits into our planning.
I would appreciate it if you do so. My time's expired. Thank you, Mr. Chairman. Thank you.
Time of the gentleman has expired. There are no other members in the queue, so I would like to thank the witness for her testimony and her patience today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witness to the chair, which will be forwarded to the witness for her response. I would ask our witness to please respond as promptly as you are able. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. This hearing stands adjourned.